Over to you, Deborah.
Thank you, sir. Welcome, everybody. Welcome to another exciting session of the Emerging Managers Program. I trust that we've learned a lot just from one class. So I'm very excited because we can see that our facilitator today is not just an ordinary person. He's a learned, I wanted to say colleague, but I'm not a lawyer. So he's a learned fellow. Lawyers claim to be the most learned people in the world. So I trust that he is very much loaded for us. He is eager, we've been talking, and I can tell that he is prepared to, I don't want to use the word bombard, but let's say bombard us, with so much knowledge. And I trust that you will not leave here the same way you came. Your mind will be transformed. And by the time you're leaving here with practical tips to take your career to the next level. Please welcome with me Barrister Marx. Please, you can't jam your hands here, but you can drop it in the chat. Let's say coming in. So please welcome him. Welcome, sir. We're so excited to have you. We're anticipating, and we know that we will not be disappointed. Welcome, sir.
Thank you very much, Deborah and Nelson, for that kind introduction. It's always good to be back on this platform, doing the what we can to just help people who we know are already on the way to just get some more clarity in terms of of how to connect their heart, as it were, to their business in the right way. So I believe I'm not just talking to people who are just starting out here, but people who already have an edge. In fact, by enrolling for this program alone, it already shows that you are really ready to take your career to another level of operation. So permit me to share my screen. Yeah, can you see my screen now?
Yes, sir, we can see your screen.
Okay, sorry, let me just go into slide mode. Sorry, the Zoom covers. Okay, well, I think I can do it somewhere up here. Where is it now? Yeah, slideshow. Okay. Okay, so you can all see my screen now. Yeah, so I will just, so for this first session, we are looking at lessons 1 and 2. Apologies, I should have put that we are doing both of them at the same time. But if I go to the outline, it quickly shows us what we'll be looking at this evening. So an introduction and just a quick primer, since this is a business law, what is law and what is business law. Then we're looking at the legal forms for business in Nigeria, which is lesson 1. So we're looking at different types, business names, companies, and there are different kinds of companies, as we'll see while we go through it today. Then limited partnerships is one of the new vehicles that was introduced into Nigeria by the Companies and Allied Matters Act, what we call KAMA 2020, which I believe most of you must have heard, since it was quite a splash, in terms of one of the new laws that we would say we can credit the present government for passing. Before this time, we were using the Company and Allied Matters Act from Okay. Can you still hear me?
Yes, sir. Can hear you now, sir.
Okay, apologies. Of course, as you all know, our Nigerian situation, I think the power companies, they are testing their equipment to be sure it's still working. But we'll carry on since you can hear me. So as I mentioned, limited partnerships and limited liability partnerships are 2 new business forms that were introduced into Nigeria by the Company and Allied Matters Act 2020. Then we'll also look at social enterprise. There are different corporate vehicles you can use to run a social enterprise. We'll look at different ones we have available. And then we'll look at the legal considerations. Okay, just a minute, sorry, I believe there should be a way I can. Okay, yeah, exactly, yeah. So yeah, we're looking at the considerations for choosing a legal structure I'll just discuss with us what we call a Delaware flip, which I think is important because it's a great tool for raising funds for startups. So we'll discuss that, but for choosing, which is lesson 2, consideration in choosing a legal structure, I want to make it a practical discussion session so that arising from what we have discussed in lesson 1, the legal forms of business, we can now critically analyze, what some of those considerations are and, what it should be in a practical sense of some of the businesses that we have represented here. So we jump in and we get started right away. So, so the first question is, what is law? So of course, certainly, some of you use a certain word. They say the law is, the one particular animal. If you remember that animal that Christ rode on when he was coming to Jerusalem. So people always say the law is that particular animal. I don't want to call it with my mouth, but I want to assure you that that is not what the law is. So essentially, the most simple definition I can give is that law is a standard of conduct agreed on by society and backed up with coercive force. So permit me to just unpack those words so that it makes it easier to really appreciate what each of them means. So first of all, so it's a standard of conduct. So a standard of conduct, like we all know, a standard is simply, in a sense, minimum operation, minimum limits that is agreed upon, in terms of certain activities or actions. So it's a standard of conduct means that it is actually, to a large extent, the law will not go beyond actual conduct to begin to, in a sense, probe and inquire into things that are yet in your mind or your heart are not yet hatched. So the law is actually governs, as it were, conduct, because why the necessity for law in society is because people have to interact with each other. So that is what the standard of conduct is all about. It's looking at the human interactions, which is a necessity in our society. Then the next word is very important. When we say agreed upon by society, it simply means that law is not something that is subjective. So I can't just wake up and say my own law is that anybody who sells pizza to me must put extra pepper, when that is not what we have all agreed, when it's not what is agreed by society. So it's not about my own subjective standards. It's about the objective standard that is agreed upon by society. And when we say agreed upon, it means that law, you can't just make up law as you go along. So if I have entered into a transaction and it goes wrong, we can't agree after the transaction has gone wrong to now say, okay, what is the law that on this transaction? So it means that it's already agreed before. The law, in a sense, is something that has already been set before, it has to be called into action. So you don't make it up along the way. So you don't wake up and say, now that I bought this car and the car has not functioned. So therefore, what we agree now is that the law is that you have to pay me 10 million because the car did not work. So that before, we can't just make it up when the situation arose, even though some people argue that the law is nothing more than what the judges say it is. In a sense, they are right, because the judge has to interpret the law. So the interpretation he gives to the law when the crisis arises, in a sense, becomes the position of the law. But even the judge, in doing that, is not calling out of his emotion or his subjective opinion at the point. He's looking back and saying, what did society agree on this thing before now? And it's now saying, okay, so that therefore is the law that governs this. So I'm sorry, this is a little, I'm sure sounding a little bit abstract, but of course, as we go into it, we'll break it down. But it's just good to have some of this abstract background at the basis, so that you begin to understand when we begin to discuss some of the practical implications of this. So then we'll also say, very importantly now, what makes law different from other, because there are many standards of conduct. Now, for instance, as Christians, we have a religious, I'll say it's standard of conduct. So we expected, for instance, like when Mr. Nelson was introducing me, that as a Christian gentleman, the standard of conduct expected of me is that I should marry one wife. I mean, we could also say it's an admonition of scripture that, a bishop should be the husband of one wife. But that's the standard of conduct that comes from the Bible. And of course, in its own way, it is binding, but it's only binding on me because I subscribe to, to the Christian faith. I mean, of course, for the Muslim, his own standard of conduct, religious standard of conduct, coming from his own religion, says he can marry 4 wives. But what is important there is that the difference between law and this standard and the religious standard, or even the moral standard of conduct, for instance, morality says if I see my elders standing, I should rise for them to sit. Now, that is a standard of conduct as well. It's also agreed upon by society because it's the moral thing to do, it's the right thing to do. But the difference between law and all of these things I've mentioned is that law is backed up with coercive force. That means if you refuse to comply with what the law says, then the law will apply sanction to you. So yeah, to an extent, you could say, yes, churches could also apply a sanction to you, but that sanction is not, as it were, backed up by state power. So the difference is that the sanctions of the law are backed up by state power. So the police, the law courts, and the other instruments created under the Constitution would actually enforce and say, look, you must comply with this. And so that is one distinguishing feature that makes law different from other standards of conduct. So law is not morality. It's not just a set of principles that are binding. It's a standard of conduct. It's agreed upon by society. So it's not just about, they are just principles. It's a standard of conduct agreed upon by society. It's not just what the, like morality, what our elders have known over years through experience. And I say, look, for a society to work well, you have to respect your elders. You have to know it's not that, and it's not just a set of conduct that is a set of standards that you help us have good conduct. It goes deeper than that. Like we say, it's a standard of conduct. It's agreed upon by society. And if you flout it, then you expect that society, through the instrument of the enforcement agencies, will bring you to book, whether it be the law court or it be the police or any other avenue that there is there to enforce those prescriptions of the law. So, like I said, this is quite high level and can sound theoretic, but as we go into it, you begin to understand it some more. So the next question is, what is business law? So because there are 2 ways to look at it. Is it a business of law? That means essentially the business of running a law operation, like I run a law firm now. Is that business law? Or is it the law of business? That means the law that operates in business. So typically when we say business law, we are referring to the latter, which is the law of business. So it is the principles of law that are routinely encountered in business transactions. So there are some types of law, for instance, that don't have any bearing with business. So for instance, election petitions now, who won APC primaries, who won the election, is the person qualified, and all doesn't really, in a sense, it's not encountered in the course of a business transaction. It's encountered in the course of election. So it's not really an issue of business law. Now, crimes generally are not business law matters. So for instance, somebody kills somebody, the gunman who invaded the church in a war, for instance, that's what we call criminal law. So criminal law, in a sense, is a different type of law. In criminal law, the aim of criminal law is that you have breached the agreed standard set by society. You have killed somebody, you have stolen somebody's goods, you have looted public funds. So what the law is doing in that case is to punish you. So it's not about assuaging the person you have done wrong to. It's to punish you, to ensure that other people in society do not follow that standard of conduct. So now that's what we call criminal law. So when it comes to criminal laws, it's quite different. So in a criminal law setting, for instance, the parties who go to court will not necessarily be the person. So for instance, if somebody steals my phone or my laptop now, when he's taken to court, when you go to court, what you will hear is not Max Ikongbeh versus Mr. XYZ who stole his phone. You hear that the commissioner of police, or you hear the state versus Mr. XYZ who stole the phone. The reason being that because what the person has done is a crime against society as written in a law, it is the society now who is going after him. So it's the person who is aggrieved by his conduct is primarily the society, and secondarily Max Ikongbeh, whose phone was stolen. But in what we call civil law, which are as opposed to criminal law, which is the law that regulates conduct between people in terms of transactions between one person and another, which is the law, which is the realm where business law falls into. Now, in that case, what the law is aiming to do is to compensate the person who has been wronged, so that he's able to, not suffer the harm, not suffer the consequences of the harm that has been done to him. So in a civil law context now, for instance, I buy a phone from somebody and the phone is not working properly. Now, that is not a crime in itself, because the person sold the phone to me and the phone, maybe not through its default, not because it's fraudulent, but because the phone, it was not, didn't upgrade properly, or the phone doesn't meet the standards I want. Now I say, refund my money, and he says no. When you were buying the phone, you tested it and you say it was okay, so you have gone with it. You can't come back and tell me that the phone is an Android 6.0 version and you wanted Android 14.0 version. So at that point, there's a conflict between me and him. So we take ourselves down to a civil court, where if I prove my case and say, look, when the man's sales lady came to me, she told me that this phone is the latest Android and all, but when I bought it, I found out that it was Android 6.0 and not 14.0. His opposition will be that, well, my lord, I agree that my sales lady told him that, but he's a learned person. When he came to the shop, he had the opportunity of looking at the phone for 5 minutes, so he should have known. Now he has bought the phone, and if he returns the phone to me now, the value of that phone over the last 1 week has changed. So I'm going to be losing money on that phone. And moreover, I have already, spent the money put into my business. So you can see that there's a conflict there. So of course, when the judge resolves and says, okay, look, by the principles of contract law, what your lady told him overrides the fact that he had access to look at the phone. So at that point, if the judge finds for me, what is happening is that the judge is not going to tell the phone seller to go to prison. He's simply going to say, look, pay him the cost of his phone. And for the past 6 months, he has not been able to get another phone because the phone was not working according to specification. So pay him damages as well for being without a phone for 6 months. So you see, the judge is only compensating me for the wrong done to me. But whereas in the case of the criminal case, it was a matter of stolen phone, the judge is not concerned necessarily about me. He's punishing the thief so that next time he does not steal. And that is why he sends him to prison. It's not just about pay back the cost of the phone. So that's just the difference of civil law and criminal law. But however, even though business law is a civil law matter, it's interactions between two private individuals. However, there are certain times where even though what has happened is a crime, that crime could be connected to business. So for instance, going off and on. I hope you can still hear me.
Yes, sir.
Yes, sir, we can hear you.
Okay, thank you. My apologies again for this back and forth with my power supply. So like I said, so essentially, but even though you are in business, there are times where things that are ordinarily criminal law matters, like police arrest, for instance, may have a bearing on your business. So the police is harassing, or AMAC, or police is harassing your coming to your office, saying that your business vans are parked in front of your premises and it's blocking the road, and he arrests your driver, for instance. Now, the arrest itself and taking the driver to court to have him punished for traffic obstruction is a criminal matter. But because it impacts the operation of your business, you can see that even though it's a criminal matter, it's having an ongoing effect on the running of your business. So sometimes what will ordinarily be a criminal law matter could actually be it could actually impact your business. And therefore, like we said, business law is those principles of law that you routinely encounter in the course of business transactions. So sometimes even what is criminal law matters end up in a sense becoming issues of business law. Then another important principle to notice when it comes to business law, why as a business person you must understand business law is because when it comes to businesses, the law does not give you the luxury of saying I was naive or I did not know. Because of course, as you know, there's a principle that says ignorance of the law is not an excuse. So even if you are not aware that the law says don't park here and you park in that place and the police arrest you, when you get to court, you can't tell the judge that, oh my lord, I was not aware that I'm not supposed to park here, because the law is provided, of course, that the road markings and all that need to be done have been done. Or you say, look, I'm new in Abuja and I'm not aware that there are some places you cannot park in Abuja and you can park in other places. It will not be an excuse. Same thing also if you for instance, come to a place and you see, maybe let's say, for instance, I joke with a friend of mine in the UK, for instance, you can go to certain parks and you see that there are swans or ducks swimming in the ponds in those parks. Now, if you kill any of those ducks, you are done for, because by the UK law, those ducks are the property of the queen. Therefore, you now just see it and say, I'm coming from a Jegun Amoja, where once we see a duck, we can kill it and eat. You go and try it in the UK, they will arrest you. You start saying that, sorry, I'm from Jegun Amoja. In my own place, the law is that any chicken or any fowl we see outside, we can kill it and eat it, and there's nothing wrong. They say, no, but here, that's the law here is that every duck you see in a park belongs to the queen. So therefore, in killing this duck, you are contravening the law. The fact that you did not know is not going to be an excuse that would save you from the arms of the law. So when it comes to businesses, there's a higher standard that a business cannot claim to be naive. And the reason is simple. As a business, the law expects you to have a legal advisor. Now, for regular citizens, there are sometimes they can claim ignorance or naivety, and the law would allow them to go scot-free. So for instance, certain class of people, for instance, like illiterates, there's what we call illiterates protection law that protects and gives them extra measures of protection. So you say, look, if an illiterate enters into a contract, we could give him cut him some slack and say, look, he might not have known, what was some of the principles of law here. So we'll give him some soft landing. But when you are a business, even though you are an illiterate running a business, you cannot fall back and say, oh my Lord, I just graduated, I'm just doing my NYC and I did not know. That would not be an excuse at all. So it just tells you that you have a burden to understand, at least to an extent, the business law that impacts your business. You should, of course, have a legal advisor who advises you in your business transaction, so that you don't fall into trouble and you think you can just get away by showing that, look, I'm naive and I'm new in the business world. So we get into the meat of today proper. So the legal forms for business in Nigeria. Now, before we delve into them, it's important to understand why we say legal forms for business. Now, because you need to understand that business is a private matter, but businesses operate within the laws, as it were, or within the authority of a governmental power. So businesses don't operate in a vacuum. So there's nowhere you go to in the world that businesses are just run in a vacuum. Businesses, in a sense, operate by the license of the governmental authority that runs that territory. So for a business to be valid and to be able to operate, you need to understand that the governing authority in that place that has made and created security and peace and prosperity and progress that allows you to be able to start and run a business, have certain requirements. So for you to run a business when you are in that within a territory, you need to understand what form the law granted to me that I can run my business with. So that's what we mean by the forms for running a business. Now, sometimes it's not just about the fact that the law says you must, but it's because in your dealing with other people, they are going to insist that your business must have a particular form. And why is this important? It's important because businesses, in a sense, operate quite different from the human being that runs the business. So when a person is dealing with my law firm, for instance, Ever Law Associates, now, if he calls my law firm and he wants me to take on a case for him, when he calls, I might not be in the office. He would need to speak to my secretary. He needs to speak to another of my lawyers in the office. So you can see that even though I am the one who originated the business and who, in a sense, in a rough way to say, owns the business, in the course of running that business, people might have to interface with me using third parties. So because of that, your business has to have a form. It has to have, as it were, a body that it operates with. So that's what we mean by the forms for business. Of course, we are talking about the ones in Nigeria. So the first kind of business form that Nigerian law allows you to run your business as is what we call a business name. So a business name is not necessarily a separate, in the eyes of the law, it's not, the law doesn't look at it as a separate entity, as a separate organization from the person that owns it. And when we come to discuss a company, you understand why this idea of a separate personality or a separate entity is very important, but we'll get to that point. But essentially, a business name is just an alias. So once you run a business using a name that is different from your natural name. So if I run, for instance, I run my law firm, it's called Everlaw Associates. Now, my name is not Everlaw Associates, my name is Marx Ikongbeh. So the moment I run that business in a different name, the law says that you must register it. Now, what is the reason behind this? Is simple. Because people are going to be transacting with Everlaw Associates. And if something happens tomorrow and they want to know who is the man behind this entity called Everlaw Associates that I've been talking to on the phone and I've been dealing with, they should be able to go to a public registry, which is the Corporate Affairs Commission, and apply to say, look, I want to know who is behind this business enterprise called Everlaw Associates. And the business registry will be able to give them a document that says, oh, well, on the 12th of May 2010, a man called Marx Ikongbeh was one who came to register and say, look, I want to be running a law firm under the name Everlaw Associates. So therefore, by law, it is illegal to run a business under any name that is not your natural name without registering. So by the Company and Allied come out 2020, you have 28 days from when you commence business to actually get it registered. Once the name you are using is on your name. So if I run my law firm as Marx Ikongbeh, that's the name I used to run my law firm, then I don't need to register it. But the moment I add anything to that natural name, then I need to register it. So typically, business name is used by sole proprietors, so one-man businesses and simple partnerships. Two people come together to say, look, we want to begin to sell ice cream. You could also use a business name, but it's a simple form of business. Some of its advantages when we get to lesson 2, when I'm looking at the considerations, would include the fact that it is very simple to run. There are no strict rules of corporate governance. You don't have to appoint a company secretary. You don't need to have directors, who have to be paid salaries and all of that. So it's a simpler form. You could run it alone. You could be the secretary yourself, the operator of the business, the manager of the business, and you are the all-in-all of that business. So it's a simple form of business. It's a very elementary form of business. We usually encourage people to start with business names sometimes and then scale up. But if you begin to get into complex transactions, then it might not be wise. And when we talk about companies now, you understand why it might not be wise to use a business name. Because when you use a business name, as far as the law is concerned, you and that business are one and the same. It doesn't see you as separate from that business. So that brings us into the second form of business now, which is company. Now, a company in the eyes of the law, now company, the word company simply comes from, the English word, which means companion. So a company is, a group of people, accompaniment, it's just that same word. That's where the word company comes from. So it's a group of people that come together to pursue a common purpose in business. That's essentially in a roughest form what we say a company. So in terms of looking at it from how that word derives from the English word companion or companionship, or a company of people. So a company, by the standards of law, is a legal personality in law, which is distinct from the owners. Now, the owners are the shareholders. Those are people who own the shares, who, in a sense, brought the company into being and who benefit from the proceeds of that company. So when the company makes profit, the profit, after it pays its tax, the company declares what we call a dividend. The dividend simply means out of the profit that the company has made, the company has decided to share some benefits to the owners, who are the shareholders, and then the shareholders get their own share of that profit as dividend. And then the other stakeholders in the company are the managers, the people who run the company, who typically at the height of them are the directors. And of course, under the directors will sit other employees and staff and all of that. But by the eyes of the law, the recognized managers of the company are the directors. So all the employees and others are simply people who are working under the directive of the directors. So now when we say a company is a legal personality distinct from the owners, what we simply mean is that when the law looks at the company, the law understands that, look, this company is going to be owning assets in itself. So the company is going to buy cars to enable its employees run around, cars for its deliveries to be done. The company is going to buy a building to house its office where the employees can come and shelter from the sun and rain while they work. The company is also going to acquire money that is going to use to run his business. It's going to acquire material that it will, transform and sell and all of that. So because the company is owning items in itself, ownership is something that is a part of what we call personhood. So one of the ways you are a person is that you are capable of owning things. So as I am as a person, I can own a phone, I can own books, I can own a teacup, I can own a pen, I can own a car, I can own other things. So the law now reasons that if we allow 20 people come together and they begin to run a business, and that business begins to own its own assets. Now, it's difficult to describe who is the owner of that asset, because if a company buys a car, you can't really say that the shareholders, 20 of them, all own that car, because while they are the owners of the company and that car is bought for the company, they cannot individually use that car for their own personal school runs. That car was bought to be used for the collective benefit of all the owners by the employees of the company. So because that, the law now reason that, look, if a company can own assets, then it is better that means the company in a sense is exercising one of the attributes of personhood. That's ownership of assets. So that is why the law views and says, look, a company is a different person in law. It can own assets just the way a human being can also own assets. So it's a person, but it's not a human person. Of course, if you are a Christian, it's easy to understand this, because just like we say, God is a person, but God is not a human person. So in the same way, a company is a person, but it is not a human person, because it's able to exercise some of the attributes of being a person. So the implication of this, I'll bring it home now when I tell you a practical story at the end. Now, one thing a company must have is what we call a share capital. The share capital simply means that it's in a roughest form, it's the value of the value of that company divided into small chunks that each person owns a portion of. So that's what it means for a company to have a share capital. So in its simplest way, what it should be is that if a company is valued at 1 billion naira, then and that's in terms of all its assets and everything is valued at 1 billion, then it should be that if those shares are each worth 1 naira, then it means that the value of the company is 1 billion and each share is worth 1 million naira. So therefore, if I own 10% of the company, I would own 10% of that 1 billion naira, which would come to 100 million naira. That's just it. So what it does is that it helps from the purpose of managing and governing the company. It helps us to know, how the relationship between the owners and the value of the company can be expressed. So I own 10% of the shares in the company means that I own 100 million ordinary shares of the company, which are worth 1 naira each. Then it also makes it easy for me if I want to sell those the shares, which are also assets. And then the share capital and all the laws and the rules governing share capital makes it easy to facilitate those transactions. So that's why a company must own a share capital. So the owners of a company, what they own in a company is their shares in the company. They don't own the assets of the company directly, but what they own is they own those assets indirectly through their holding of shares in the company. Now, of course, like we said, the idea of a company is that it must be more than one person. That's the standard idea. But after a while, the law has realized that, look, whether I like it or not, some human beings, even though they have 2 or 3 people joining them to form a company, but they are the directing mind of the company, everything about the company is controlled by that one person. So because of that, under CAMA 2020, it's now possible for one human being to own a company. It's kind of a fallacy in a sense, because a company is supposed to talk about more than one person, but you are now a company and yet you have no companion. That's just a fiction of the law, which recognizes the reality that most companies only have 2 people as directors, but yet it's one man, or maybe the man starts a company, his wife is his co-director, the children are the other directors, they know nothing about the company. He runs everything, he's a social signature to the bank account, he has an ATM card to the bank account, he runs everything by himself. So the law has now said, look, we know that we have tried to say, look, no one person should own a company, but since you people have insisted, we have given you the opportunity, you can be a one-man company. Then also a company could be a private company or it could be a public company. The implications of private or public company, we'll discuss it more when we talk about the considerations for for choosing a legal form. But essentially, by law, the law understands that some people may want to regulate their affairs in a more close-ended way without making the back end of their business open to excessive public scrutiny. So that's why private companies are allowed. Now, private companies are companies that have less than 50 members, 50 shareholders in essence. So these are companies that also have certain other rules governing them. That look, within a private company, for instance, if you say you are tired of being a member of the company and you want to sell your shares, you can't just walk to any third party and sell your shares to him. The reason being that when you came into this private arrangement with others, the belief was that, look, it is we who know ourselves who want to privately run this company. So if at any point in time you want to leave and exit the company, you cannot just go and sell your shares to a third party. You have to offer it to those of us who are within the company. It's only when we are not able to buy that you could sell to a third party and bring them in to the fold. So a private company is a simpler vehicle to run because it's a private thing. So you guys just run your thing yourself. And it is run by private finance, essentially. Now, a public company, on the other hand, is a company that, of course, exceeds 50 people or can exceed 50 shareholders. It's a company that's allowed to raise money from the public through the stock exchange. Now, in return for the privilege of being able to raise money from the members of the public, there's heightened corporate governance requirements that are on you, heightened disclosure requirements that you must meet, because you are collecting money from members of the public. Therefore, the public have to, have access to see your books of accounts, to know how well the company is faring and all that. And then there are many other stringent requirements you must meet to be a public company. Of course, the principle of the policy of the law there is simple, because the law says, look, if we are allowing you access to raise money from members of the public, then you must also be open. You must also be accountable to a heightened extent to the members of the public. So, like I said, when we get to discussions on considerations, we'll look more at some of the fine details why a person would pick to have a private company or have a public company. Of course, typically, most people start with a private company, and then as the company grows and all, then you get to a point where you say, look, we want more money. And we ourselves, as a private group of people, are not able to raise that kind of money. We want to get money from members of the public. So we want to go public. Then, of course, at that point, you have to transform your company from being a private company to a public company, and then you can list on the stock exchange. You can sell your shares to the public. Anybody can buy, and you can raise more capital that way. Then also, just the same way as companies can be private or they can be public, companies can also be limited or unlimited. Now, when it comes to limited, now that's the heart of company law. If you remember when I told you about business names, I mentioned to you that in the eyes of the law, you and your business name, you are one and the same. So it therefore means that your liability to the business is not limited. It means that if anything goes wrong in that business, any debt that business is owing is attributable to you, the human being who is running the business. But what the remarkable thing that the law of company does is that by company law, the law allows you, the owners of the business, to limit your liability, your exposure to the business. And the case study I'm going to give you now would explain this in clear terms. But it's also possible to have a company and decide that with this company, the liability will not be limited. Now, unlimited companies are rare. In fact, in Nigeria, as much as I know, I think the only unlimited company we have is called Mobile Unlimited. I think it's Exxon Mobil, yes. Mobile Unlimited is about the only unlimited company we have in Nigeria. Because the implication of an unlimited company means that if that company goes bankrupt or anything goes wrong with that company, the owners, the shareholders of the company, you have to, from your own personal pocket, pay up every debt that company is owing. So let me give you a practical case scenario now that drives in the point and really explains what is at the heart of company law, which is this issue of limited liability. Now, it's the last point on my screen, which is, I call it the case of multiple personality disorder. Meet Mr. Solomon. So let me explain how, the background story. Mr. Solomon was a cobbler, a shoemaker, but of course, when we say shoemaker now, it's not, in those days, shoemakers were a little bit more prestigious people than what they are now. I mean, this happened, I believe, in the early 1800s in England, but cobblers then were a little bit more highly revered, just like carpenters now. Say when Christ walked on the face of the earth, he was a carpenter. I mean, if you try to see it in the context of now, you miss it, because carpenters of business are like maybe what we call architects now. So cobblers of those days are, in a sense, equivalent to who the people call designers of these days. So it's not the shoemaker, the Hausa shoemaker going around waiting to show your shoe. So he was a cobbler who was running a successful cobbling business in his name. He was running it as, as a Solomon and Sons cobblers, not a company. And the business was doing well. At a point, he now heard about the fact that he could convert his business into a company and some of the advantages that he has, access a loan with it and all that. So he decided to convert his cobbling business and form a company called Salomon and Sons Limited. So when he formed Salomon and Sons Limited, he valued the cobbling business. He said, my cobbling business is worth £28,000. So therefore, this new company I have formed will buy that my cobbling business from me at the rate of £28,000. So based on that, his company, after forming it, now went out and collected loans from people and collected money from others and sold shares to them. And in return for that, he now took that £28,000 and of course spent it on himself personally. Now, after forming the company, of course, he was still the sole director of, he was still the managing director of that company, and he was still the one running the business. But he paid himself, which is something you can do in the sense that if you have started a venture, maybe as a business name, and it becomes successful, you can value it and say, look, the value of this, my business is XYZ amount of money. So I'll incorporate the company, and the other shareholders who buy into the company, as they pay money to the company, that money will be given to me to settle me for selling my going concern, my going business to this company. Like I said, because the company is a separate person from Mr. Salomon. Even though when you look at the company, the name of the company is Salomon and Sons. If you go to the office of that company, it is him you see there, it's him you are transacting. So when Salomon did this, the company went ahead to take some loans and all of that. And then the business went bankrupt. So the other shareholders and the banks who took the loans say, no, this, you can't tell us that you are pocketed at £20,000. We can see that you still have at £20,000. You are buying houses, you are buying cars, and you are telling us that the company has gone bankrupt, and we should say we have lost that money, or we should go and look for Salomon and Sons Limited to pay us our money back when Salomon and Sons Limited is bankrupt. And the man said, well, yes, the loan you gave it to Salomon and Sons Limited. You didn't give it to me, Mr. Salomon. So even though I have my personal assets, you cannot take my personal assets to satisfy your loan. And when the people took him to court, the judge said, yes, he's right. Your loan and your shares, you bought it in Salomon and Sons Limited. Salomon and Sons Limited is not the same as Mr. Salomon. Therefore, even though Mr. Salomon has the £28,000 still in his pocket, you cannot reach into his pocket and take that money out, because the person you gave your money to is Salomon and Sons Limited. And as Salomon and Sons Limited has gone bankrupt, you have lost your money. So you can see it's quite a dangerous matter. So what Mr. Salomon enjoyed is what we call limited liability. Even though he had money in his personal pocket, you could not take his personal money to satisfy the business debt that the business was owing as at the time it went bust. So it's a powerful tool. Essentially, it gives you the comfort that when you start a business and things go wrong, that you are in a sense protected. Your debtors will not come after you and take all your assets and leave you homeless just because your business went bankrupt. Like we say, it's a double-edged sword. Some people think it's unfair. I mean, why should I see the man driving a car and I can't go and seize his car? And yet he's telling me stories that the loan I gave to him, I gave the loan to his company, and the company is not able to pay the loan back, but yet he has money and his company does not have money. So it's a crazy situation. But as we discuss some more, I'm sure you get to understand more. Of course, the law is not foolish. There are situations where if the law knows that the person set up a company as a scheme to defraud people, the law say no. This particular company is a fraud. So therefore, would overrule the impact of limited liability and allow people to proceed against the owner or the promoter of that company and recover their money from him in his personal capacity. So please, as I'm speaking, please, if there's any questions you have, you want to draw me back and ask questions or clarify any concept, please feel free to do that at any point. Don't wait until the end, until you get to the question and answer sections. At any point you feel you want more light to be thrown on any issue, please feel free to stop me and let's go back and have a look at that area. So I hope we are good to go at this point. I would just like to get a confirmation from somebody that we are good to go and that you are following so far. I want to hear from one of the participants. Are we good so far? Are you following? So I can see who. Let me call Ifeoma. Ifo. Are we good to go? I can see Ifeoma. I can see Richard Jeremiah.
Yes, sir.
Okay, excellent. Yeah. So I wanted to just be sure.
Go, sir.
Okay, oh, these are doing okay. Excellent. Yes. Yes. So we are good to go. You are getting it right.
Yes, sir.
Okay, perfect.
Yes, sir.
So please, anybody has any question, feel free to stop me at any point. So now we go to another form of business. So we have what we call limited partnership. So if you remember, I mentioned earlier that you could also operate a partnership under a business name. But like we said, with a business name, there's no difference between, you don't have the benefit of limited liability. So if anything goes wrong with that business, then your personal car, your personal house, and all can be sold by you to recover whatever the business was owing them. Now, those are so basic forms of partnership. Have unlimited liability, and you go under you can register as a business name normally. But the law also recognizes that sometimes people get into a partnership, and one person has one person is the person running the partnership business. The other person is only funding that partnership business, so he doesn't really have an idea of what is happening within that business. And the law recognizes that, look, it might be dangerous to hold both of them up to the same standard of unlimited liability. So limited partnership is the answer to that. It's a special type of partnership where the law allows one party, called the general partner, who is the one who runs the day-to-day operations of the business, to have unlimited liability, while the other partners, called the limited partner, has limited liability. That means that limited partner, if anything goes wrong with the business, beyond the money he has committed, he will lose, of course, the money he has committed to the business. So if he put 10 million into the business, for instance, and the business goes bad, he will lose his 10 million. But assuming the business was owing somebody 20 million, the person in the business was owing 20 million can go after the general partner, who is the person who was running the business day to day, and say, look, I'll sell your car and I'll seize your house, of course, by judgment of court, not that you do it by yourself without a court judgment, or you can't do it what we call through self-help. So you can't just go to his house and block his gate and seize the key to his car and fight him, or take area boys to do it. But we're just saying that using the court, for instance, you can get a court order to say, look, his car and his house should be sold to settle your 20 million debt. But for the limited partner, the only thing he's losing is that 20 or is the 10 million he has invested into the business, or you cannot come after him to sell his car, to sell his house, to get your money back. So that means there's the limited partner, enjoys what a shareholder in the company will enjoy, which is limited liability. So of course, the policy behind this is simple. The general partner is the one who has an idea and who is running the business. So he should be the one to take the hit if the business goes wrong, because he's the one who was managing it. So if the business goes bad, then in a sense it's mismanagement that made it go bad. So he should face the music. So one place where limited partnership is used, relevant to startups, is what we call venture capital firms. So venture capital firms, we'll discuss them a little bit more, operate with this principle where the general partner is somebody who knows how to spot startups that have prospects and fund them and hope that they grow, they become big, and then is able to cash out by selling his shares when the company has a valuation of that startup has increased, just like you have heard about Flutterwave, for instance. So, but however, the general partner would not always have all the money to put into those small businesses. So he needs the limited partners who will give him the money. Then he will now exercise the judgment of identifying the right startup to put the money into, mentor those startups, and monitor them, evaluate them, ensure that they actually grow in valuation. And then he cashes out, and then he pays back the limited partner. And then, of course, he keeps some of the money. So this is one industry or one sector where limited partnerships operate. Another special type of partnership are limited liability partnerships. In limited liability partnerships, all the partners can have limited liability. So this is mostly used by professional organizations. So like lawyers, for instance, because by law, law firms cannot be run as companies. So because of that, and even architects also have the same limitation. So because of that, okay, no, I think architects, there's a way they could actually do it, separately. But by conventional standards, most of them are not allowed to run as companies, and there are certain requirements why that is. So in those situations, limited liability partnerships becomes a good vehicle for professional firms to operate with. Sometimes also you don't want to incorporate a company because a company has a lot of high-level corporate governance issues and all of that. You don't want all those wahala of filing reports to CAC every year and all, well, of course, even limited partnership will file. But I mean, there are certain things you have to report in your filing to CAC as a company, and maybe you just want something more simple. You can run as a limited liability partnership because, in a sense, what governs your internal rules and mechanisms is your deed, your partnership deed, which is a document you drop, and you can set the rules that govern your partnership according to what you run. But if you incorporate a company, there are certain minimum requirements of the law that you cannot exclude in the operations of your company. So that's why sometimes you might want to run a limited liability partnership rather than run a company. So like I said, when we get to the practical sessions, we really begin to break down this thing and really discuss in practical terms what these things mean. So the last forms of legal business are social enterprises. So social enterprises are simply businesses that are run. I call them businesses advisedly because they may not in the conventional sense be a business because the aim of every business is to maximize profit. But for social enterprises, it's not exactly to maximize profit, but to solve a societal need. But however, even while they are solving a societal need, they need to still run in a way that allows the social enterprise to be sustainable in terms of raising enough money to keep fulfilling its objective. So people use the word non-profit. So they say non-profit sector. So because of that non-profit sector, the thinking sometimes is that a non-profit entity cannot make profit. But that's not exactly the right way to say it, because so far as the earth is concerned, if anything is going to be sustainable on the face of the earth, then it has to make profit. And profit sometimes could not even always be cash. But it simply means that profit simply means that you need to maximize returns on investment. So even non-profit or NGOs, social enterprises, in a sense, are still allowed to make profit. What they can, however, not do is that the correct way to say is that they are non-profit sharing. So they can make profit and not share profit. So businesses, companies, limited partnerships, and all other forms I've mentioned exist to maximize profit and share the profit to the owners or to the shareholders. But for social enterprises, they can make profit. However, they cannot share that profit. They can't distribute it as dividends to their stakeholders. What they have to do with that money when they make profit is to plow it back into meeting that societal need, because the law allows them certain benefits. For instance, they don't pay tax because it's believed that, look, the money they would have used to pay tax is what they are using to meet a need in the society. So actually, social enterprises, of course, what stands out about them is that they are tax exempt, they don't pay tax. But however, you need to know that it's not all income of social enterprise that is tax-free. So for instance, a church is a social enterprise, but if a church establishes a bakery and begins to sell bread and makes profit on that bread, he has to pay profit on the income of that bakery. But when the income of the bakery at the end of the year is because the bakery which the church is running or the NGO is running, for instance, is running it as a business. So it means it can declare profit at the end of the year. Now, when that profit is declared now, and the church, for instance, is the 100% owner of that bakery, and the bakery pays the church 10 million as the dividends that of the profit after tax that that bakery which was established had made. Now that 10 million comes to the church, and the church cannot now say, okay, to all the pastors share this money as your end of year distribution from our business. No, what the church can do with that 10 million is use that 10 million to meet the need in the society that it was set up to do, which is to propagate the gospel. So same principle applies to NGOs as well. So we have heard that argument about churches should be taxed, after all they are making a lot of money and all of that. But the principle of the policy of the law there is simply that, look, if that non-profit sharing organization engages in a profit-making venture, then it should pay tax, just like any other profit-making venture pays tax. But however, where the organization, social enterprise, is running on grants, is running on tithes and offerings, then it shouldn't be paying any tax, because That is money that people are giving to them to say, look, we are giving you this money because we want you to use it to solve a problem in society. And provided the organization is using it to solve that problem, then it won't pay any tax. However, another important thing to note about social enterprise that even though you are not paying tax, you still have an obligation to file your tax returns at the end of every year. So you are supposed to submit your books of, your audited books of accounts to the Inland Revenue Service. Say, look, in this business year in question, we got a 10 million naira grant from USAID. We got a 20 million grant from DFID. We got donations from the local chiefs in this community. We got donations from our partners totaling 100 million, and we're able to expend 90 million on providing water, or providing sanitation and hygiene, or providing education for less privileged children. And we have retained 10 million to carry over into the new year to run our business. So you need to file that return. So you are not paying a tax on that 10 million because that's the money left after you have finished your business, your activities for the year, but you need to file that returns. And if you don't file the returns, you'd actually be assessed to pay penalties for not filing them. So it's something that social enterprises need to be aware of, that you are not paying tax, but doesn't mean you still have to comply with tax. Also, there are two basic vehicles you can use to run a social enterprise in Nigeria. One is a company limited by guarantee. So a company limited by guarantee is a company, just like any other company. The difference is that the company doesn't have a share capital. And the company doesn't have shares. The people or the shareholders of a company limited by guarantee simply guarantee that if the business of this company goes bankrupt, I guarantee to produce 100,000 naira, to settle whatever liabilities are left when the company went bankrupt. So it's a company just like any other. It has directors. It's run almost like a company, but it doesn't have shareholders in that sense. Rather, it has members who have guaranteed that if the company goes bad, they'll be able to a certain amount make good whatever liabilities the company has. So it's also exempt from tax, just like any other social enterprise, and then it also has certain rules and regulations of corporate governance. So you need to have directors. The directors have to meet certain standards, and there are many other rules you have to fulfill as a company by guarantee. Another way to also have a social enterprise is by incorporating what we call incorporated trustees. So incorporated trustees in the eyes of the law is not necessarily a separate entity like a company. An incorporated trustee actually is just a group of people that have come together, that an association of people have appointed to stand as the recognized face in law for that association. So an incorporated trustee essentially is just a person who stands in position of trust to hold the assets and liabilities that belong to a group of people who have come together for a social, educational, or other societal related cause. So it could be, for instance, some churches register as incorporated trustees. Ex-student association can come together and say, look, old boys association, let's appoint 3 of us to go to CAC and get incorporated as the trustees, so that they can hold all the assets that belong to this association. So for instance, the association can say that we want to buy land and build an estate. So these 3 trustees will trust you. You are reputable people. So therefore, CAC recognize them as our trustees. Let them be the ones to sign every time we need to open a bank account, when we need to start developing the estate, we need to engage a contractor to build the estate for us. So all kinds of social organizations can come together and get themselves set up as an incorporated trustee. Pure NGOs too can do it, and all of that. And then the difference between company limited by guarantee and incorporated trustee typically is that with company limited by guarantee, there are already minimum requirements of the law as a company that you must meet in terms of how you run the organization. You need to have directors. The directors have to be people who meet certain criteria and all of that. But for incorporated trustee, just like I told you about partnership, where it is your private document, your deed of partnership, that regulates the conduct of how the business of the partnership is run. In incorporated trustees also is what we call a constitution, which is a private document signed by the members of the association that governs how that organization is run. But for a company limited by guarantee, and just like companies, it is the law, the Company and Allied Matters Act, that determines the rules that govern how the company is run. So sometimes people pick incompetent trustees because it gives you the flexibility to design how you want your social enterprise to run. You don't want to be bound by some of the rigid requirements of the law that apply to a company limited by guarantee. So yeah, so we are done with lesson 1. So I think we have spent, okay, well, yeah, we had an hour for this, and I think we have used 1 hour for it. So I guess at this point, I'll pause for us to have a question and, just entertain a few questions and answers. So I have some questions. We should have put them as a Q&A test on Google document, but unfortunately, I wasn't able to get that typed up. So what will happen is that I'll read them. They are like objective question answers and less all answers. So I think to make it interesting, what we'll do is that each person will write your answer down before we now agree and discuss what the answer would be. I believe this would work, Deborah, since we are not able to type up and present them as questions. I apologize for that.
Yes, sir. It's good since it's interactive. Yes, sir.
Okay, good. So, but before we get to the test, I think we'll take the second lesson before we get to the test, so that the test will be for both lessons. But I want us to just give ourselves 5 minutes to, ask questions, quickly review what we have discussed here before we go into lesson 2. So, as my manner is, I'm not only going to wait for questions, I'm going to begin to call people to just, ask questions, throw any comments, anything that comes to mind. So, but if you have a question, please just feel free to unmute and ask right away. I know it's been a little bit technical, but I hope when we get to the second segment, it will be more interactive and less technical, and able to appreciate and understand how these things play out and how they apply to your business that you currently are doing. So please, I want to at least, yeah. So yes, Odun, let's hear you.
Hello, good day, everyone.
Yes.
Okay, so I wanted to ask about social enterprise, because I think that's where I'm aiming at. So for social enterprise, what's your take about it? Does it operate more like an NGO, or you can still, because of course we know we are here to make profit, but also like give back also? I just want to hear, like, because that's really where I'm really, thank you. That's my question.
Yeah, thank you. Yeah, so essentially, social enterprise is just the catch-all phrase that involves NGOs, religious organizations like churches, charity organizations, development organizations, to a large extent, are all captured under the broad phrase social enterprise. Social enterprise just distinguishes them from enterprises that are driven purely for profit and for commercial purposes. So commercial enterprises, like companies and the other businesses we mentioned, are run solely for the purpose of maximizing profit, getting returns on investment, and making their owners richer and all of that. Even though, of course, we understand that even with them, there's some obligation on them to, still have some social purposes to benefit, mankind beyond just making all the money you can make. So there's what we call corporate social responsibility, which is a non-binding obligation that commercial enterprises take upon themselves to ensure that they're able to still benefit the society, even though they are set up for the pure purpose of making money. But when we say social enterprise, we're just trying to say these are a group of people that the overriding purpose why they are set up is not just to make money for the owners. It's not just because the owner wants to, even though we are saying sometimes even when you are running a business, you are not running the business just purely because it's only money you want to make. Sometimes what you want to do with a business, so I'll give an example, for instance, with something like Daily Momodu running Ovation now. With Ovation now, he was making money, no doubt. But you could see that the greater thing he was making from that company was more than money. It was goodwill, network. Was, because he got to a point where the benefit he was making from there is that people want to have certain events and occasions, and they just want him to be in the room. And by being in the room, because you just want him to give you that coverage that makes your event, trendy and within the social sphere. But you can see that apart from making money from that business of Ovation, for instance, he also, his social capital greatly increased, and he's even using that social capital now to go into politics and all of that. But we are just saying that for social enterprises, the distinguishing factor between them and commercial enterprises, they are not just out to benefit one person or just a group of people. They are out to benefit society as a whole. So because of that, like we also said, they can be run in two ways. They can be run as a company, just like any other company, provided that there are some differences. That at the end of the year, they don't just sit down and say, look, this company, this year we made 100 million. Our tax is 30%, 30 million. So the remaining 70 million, let us share. You have 10% of the company, so take 10 million. You have 20% of the company, so take 14 million. So that's social enterprise will not do that. You only use the money to fund your objective. So for instance, if a social enterprise is going to be brought to an end, so for and it comes to an end, the law is that the money cannot be shared. You take the money and look for another social enterprise that has the same objectives as you and give the money to them. But if a company is to be wound up or to be folded up, what will happen is that you sell all the assets of the company, you settle all the creditors and all the and all the people that the company is owing. Then whatever money is left, you give it to the shareholders according to the share of the company that they own. But for a social enterprise, you don't do that. When you wind up a social enterprise, you settle all the obligations and the debtors and all the people you are owing. Whatever money is left, you now look for another social enterprise that is doing the same kind of, that has the same objectives or the same line of societal needs is meeting as your own, and then you give the money to them so that they can continue meeting that need. So that's one huge difference between commercial enterprises and social enterprises. So social enterprises must just be run according to those rules, and then there's like I said, a different structure, either as a company limited by guarantee or as an incorporated trustee. You might want to select incorporated trustee because you want less relaxed rules of corporate governance to apply to your social enterprise. You don't want to run it as a company where you have to have a company secretary, you have to file certain kinds of documents, you have to keep certain records, you have to run a certain way. But with an incorporated trustee, you can just write your own constitution and say, this is our constitution. We have a treasurer who keeps all the money. We have a financial secretary who audits the money. We have a PRO who would help us post on social media to publicize our events. You have the free room to design how your organization will be run as much as possible. So I hope that throws some more light, Odun.
Wow, yes, thank you so much. It's so enlightening. So thank as you. In this latter part is so eye-opening because so you cannot share profits.
You cannot.
Right,
you cannot.
So
but however, there's leeway. So but there's some leeway. So even a social enterprise can pay salaries. It can pay honorarium to the founder. But what we are just saying is that whatever money the social enterprise is giving to the founder has to be tied to some direct value. It cannot just be for the sake of the fact that you own it. So I mean, some people do what is not exactly right. So they pay themselves very bogus honorarium just for the person. But in a sense, why social enterprise usually has some measure of self-regulation is that the donors who give the funds usually, in a sense, already put some form of check and balances to be sure that, look, we didn't give a 10 million grant to these people and they just pocketed the money and shared it amongst themselves. So, of course, next time when you come for a grant to say, look, we want to buy mosquito net and for malaria prone, I say, no, the last grant you were given, come and justify how you spent that grant. So by the time they now see that honorarium of the fund that was 4 million out of the 10 million that was given, they say, okay, this one is just using NGO to benefit. So there's some form of, but I mean, there's still abuses, a lot of abuses in the social enterprise sector. But then there are proper ways you can do it. You can put yourself on the salary because you are also an employee of the NGO at that level. You can give yourself an honorarium for, okay, every time the board of directors of the NGO sits, we give ourselves a reasonable honorarium for leaving our other busy engagements to come and discuss how to move the organization forward. So there are some leeways there, but just that you cannot do outright sharing of money like the shareholders in the company can do. So any other question before we move on? So by 5:30, we'll start lesson 2. Okay, so I can see Monday, Akachukwu says, what is the standard that one can reach before he or she can become a trustee of a company? Okay, so let me try to clarify that now. So trustees only operate with social enterprise in incorporated trustees. For companies, the managers have to be what we call directors. So by law, The director of a company, number one, has to be a person who is an adult, so you can't be below 18 years old. Number two, you have to be a person who has never been convicted of an offense involving fraud. Number three, you have to be a person who has not been declared to be of unsound mind by a court of law. Then, of course, you have to also be somebody who has depending on some companies. So, like certain companies, like public companies or companies in regulated industries, like banks and all, you have to be approved by the CBN, for instance, to be a director in a bank. So it's not just about the fact that you meet these minimum requirements. They have to check what is your experience in financial matters. They have to check they have not been blacklisted in the banking industry before, and also there are heightened requirements. So there are heightened requirements before you can be allowed to become a director in those regulated industries. So insurance industry as well, and so many other. And then particularly once you are in a public company, there are so many other requirements that automatically are binding on you as a director. So, but essentially, to be a director of a company, direct answer to your question on Monday is a very low mark. Anybody actually can be a director. Once you are an adult and you start a business and run a business yourself, automatically you are qualified to be a director in your own business. Provided you are not now trying to become a public company and access public funds. The moment you do that, then heightened requirements begin to apply to you at that point. So anybody who can run a business can also be a director of a company. So any other question? So by 5:30, we'll just give ourselves a 5-minute break, stretch your leg, get some water to drink before we start lesson 2. So any other question before we commence on the break?
Okay, good evening, everyone.
Yeah, evening.
This is not my question, but I noticed someone asked the question on the group. Thank you, former Chinecherem Oji. I thought she wanted to confirm or to be clarified on the difference between limited liability and unlimited liability. So please, sir, if you can maybe give some highlights.
Okay, thank you. So let me just give a practical example now that really helps you to understand it now. So imagine I form a company called EMP Limited. And in EMP Limited, I own 90% of the shares in EMP Limited. And Chibuzo is the second shareholder, and he owns 10% of the shares in EMP Limited. At the time we formed EMP Limited, we decided, because at that point the company doesn't have any assets or yet, so we just create a share capital, which is a notional value. We just decided, okay, this company, we believe as startup, our value is worth 1 million naira. So we decided that 1 million is our startup share capital. So it means therefore that for that 1 million now, which is the startup capital the company is going to use to commence its business, I'm supposed to pay 900,000 to the company, and Chibuzo will pay 100,000 to the company. So the company now has 1 million. So with that 1 million, the company can now go and start, maybe buying phones from China and begin to turn over the profit. And after year 1, business has been good. The company has made, profit in the region of 2 million, and the company has acquired assets. He now has a staff boss. He has an office space and all of that. And then the value of the company is increasing. Then imagine that the company has run for 10 years and the value of that company becomes 100 million. Now, my liability to the company is simply that 900,000 I paid to the company. And Chibuzo's liability to the company is 10 million I paid to the company. So, and we're giving that money to the company, so we're not owing the company any more money. Now, in our 11th year of operation, we now see that there's an opportunity to scale this company to start manufacturing phones in Nigeria. We now approach Mr. Nelson, who gives us a loan of 200 million naira to establish that factory. We establish the factory, and then, due to some unforeseen circumstances, things go bad and the business loses value, and the business at that point has to close down. Now, when the business closed down, the only assets that the company had left was still just 100 million. So by the time we sell off the staff boss of the company, we sell off all the other assets of the company. All that we are able to realize is 100 million. And we pay that 100 million to Mr. Nelson, who we are owing 200 million. There's still another 100 million left that we have not paid to Mr. Nelson, from the company EMP Limited. Now, the normal thinking is that Mr. Nelson is okay, fine. Since 100 million is left, you, Max, since you have been running this company, you have been collecting salary as a director, you have also been taking dividends every year. You have built a big house in Metama. You have 7 cars. And by the time I take that house and I take this house and I get my 100 million back. That should be the normal way he's thinking, because in a sense, the person he knows that he gave the money to was me, Max. And yet Max is telling him that no, all you are going to get is 100 million, because my liability as the owner of the company is the 900,000 that I contributed when the company was formed. My liability is limited. So beyond that so it's only if you go and check the books of the account to find out that when this company was formed, Max took 900,000 shares. He was supposed to pay 900,000 to the company, but he never paid it. So you can come after me to pay that 900,000 to the company, and you give it to Nelson, and yet Nelson will still be left with 999 million, less the 100,000 that I've paid back, 900,000 I've paid back to the company. So you can see that what is happening essentially is that my liability, my obligation to the company is only to pay for the share that I took in the company. So if anything goes wrong with the company, any third party that had transactions with the company is at a loss. If the company's asset is not enough to pay him off. So that's what we mean by limited liability. So at the moment I've met my obligation of the shares I took in the company, I don't owe any other liability to the company. So that means if you form a company today, in doing that, you are safeguarding yourself to say, look, this business I'm going into is a risky venture. If the business goes bad and fails, people should not be able to come and take all my assets, take all my cars, take all my, and leave me penniless completely. So that's why you would want to use a company in running your business, to give yourself that cushion to ensure that even if things go bad, your liability is limited only to the amount of money you have committed to the share capital of that company. Of course, there are some other losses you would take. So for instance, when the company folds up, normally the whole 100 million that was the assets of the company, if the company folded up in a healthy state and the company was only owing 20 million, when you wrap up the company and sell all the assets, you pay the 20 million, you're supposed to share the remaining 8 million amongst yourself. So you are already losing that if the company has gone bankrupt and the company was owing debt to third parties. So it also means that even if the company was owing the 100 million people, by the time you wind up the company and sell all the assets, that 100 million, you will not be getting anything out of it because those third parties will take the money. But it also means that if the debt the company is owing is more than the assets of the company, then those outsiders are losing money because they cannot go out beyond the company to now ask you as a person to pay up that liability. So I hope that makes it clearer. I know this is technical.
Yes, sir, very clear.
Okay, thank you. So let's give ourselves a 5-minute break just to stretch, and then we'll come back for lesson 2.
Thank you very much, sir.
Thank you.
Thank you for that enlightening session. So if we still have any questions, we can drop them in the chat. For the meantime, just grab some water if you need to take water, stretch your legs, think about the things that were taught. Think about how it applies to, if you're an entrepreneur, think about how it would affect you if you have a plan for a business in the future. Just ruminate on it. And then we'll get back once it is 5:41.
Okay, yeah, thank you, Deborah. I hope everyone can hear me now. Can you hear me?
Yes, we can hear you. We can hear you,
Yes,
sir.
we can hear you.
Okay, excellent. Yeah. So now we go into the second lesson, which is considerations in choosing a legal structure. So like I said, I'll just quickly throw light on something called the Delaware flip. It's something that's happening a lot now. So it's just good to make your mind think about it. Just don't get stuck in the complexities of it. Just try to get an idea of the hang of what it's like. Then we are going to go into the discussion segment where we'll actually be going back to look at the legal forms I've discussed now to now begin to discuss in more practical terms how the different factors would weigh on your mind in designing your business. Now, a Delaware flip is something you should know about, because if you follow the news, you'll be hearing things like Flutterwave has just closed a 10 million Series B funding round. You'd hear that a new fintech has raised $3 million to combat this in Africa, or to make payments easier. I'm sure we all hear that kind of news regularly. I'm just wondering, this money, where did they see them? So one of the things that's at the bottom of that is what we call a Delaware flip. And I'll explain Delaware flip and then try to tie it into the news you are hearing. But why this is important is that a Delaware flip has almost become a minimum requirement if you are going to raise foreign private equity capital for your startup business. So a Delaware flip, so Delaware, of course, first of all, you need to know, is just a state in the United States of America. That's where Joe Biden comes from. It's a state close to Washington, D.C., I think, yeah, somewhere there on the eastern seaboard. Now, the reason why Delaware has become popular is because in the U.S., unlike Nigeria, in the U.S., each state, actually, because they are a proper federal structure, each state has its own company law different from that of other states. So in the U.S., technically, if you register a company in the U.S., you only register a company in one state. So technically, you can't, if you want to have a company that is going to operate in the whole of the U.S., you have to register 50 companies in all the 50 states. That's notionally. I mean, of course, there are ways to go around it without having to go through that difficult terrain. But of course, we know in Nigeria that there's one Corporate Affairs Commission in Abuja or in other states, but any company registered in Nigeria automatically is registered, in the whole of the federation. But this is not so in the US. So Delaware is a state that, as a deliberate policy, decided to make their state company law attractive to foreigners and to, foreigners both in terms of US residents of other companies, US residents of other states in the US, and then foreigners who are, people who are resident outside of the US. So, for instance, almost every big company in the world, in the US, for instance, MasterCard, all the big companies in the US, they are all registered in Delaware, even if their headquarters is in California or in other states in the US. But you would see that their primary registration is in Delaware, because the Delaware company law is very favorable. There are certain things that make it very unique. Its tax laws also applying to companies also very favorable. So people prefer to use Delaware as a place where their companies registered to benefit from some of these things. So a Delaware flip is a corporate restructuring exercise where the shareholders of a non-US company incorporate a US company, usually in Delaware. There are other states in the US also that have learned from Delaware and also trying to attract people to register in their jurisdiction. So there are a few of them now as well. So after the non-US, the shareholders register their non-US company in Delaware in the US, then what they do now is that they transfer the shareholding of their non-US company to the new company they registered in Delaware, and in return, the new Delaware company takes 100% of the shares in the existing non-US company. So let me just break that down so that it doesn't sound too complex. So I'm running a company, EMP Limited, in Nigeria, and I'm trying to raise funds from, what we call private equity funds. So these are people, like I said, venture capitalists, people who will look at startups and say, look, this startup looks like it has prospects. Would buy into their company now. Their valuation currently is 10 million. So if we buy 20% of their shares, we buy it at 2 million naira. If we invest in them and we guide them and they build properly, maybe in another 3 years, they'll be worth 1 billion. So our investment of 2 million in them, which earned us 20% of the company, in 3 years' time will be worth 200 million naira, which would be a good return on investment. So they have not told me that, look, Max, our fear is that we want to invest in your company, but your Nigerian law is very unstable. We can invest in your company now. Tomorrow we'll hear that there's a problem in the company. We'll go to court and we're going to spend 20 years there. So to give us comfort, flip your company to Delaware. That means incorporate. So I'll go to, so flipping, what I'll do is that I go to Delaware and I register EMP LLC. That's EMP, which is like the US equivalent of a limited company. So I now register EMP LLC in Delaware. Then, having registered EMP LLC in Delaware, now I and Chibuzo will take our normal shareholding, the EMP LLC in Delaware. So I'll have 90% of the company. Chibuzo will have 10% of the Delaware company. Then that Delaware company will now buy over our Nigerian EMP Limited and become 100% shareholder of EMP Nigeria Limited. So you can see that by doing this, in the sense, I and Chibuzo are still enjoying the same benefits, because when EMP Nigeria Limited makes 100 million, formally, I will take 90 million, Chibuzo will take 10 million. What's happening now is that if EMP Nigeria Limited makes 100 million, it will give the whole 100 million to EMP LLC, the Delaware company, and then EMP LLC, the Delaware company, will still give me 90 million and give Chibuzo 10 million. So you can see it's still the same thing. What we have simply done is that we have just re-engineered it to ensure that the Nigerian company is now owned 100% by the US company, and then our normal shareholding is now held in the US company. So the foreign shareholder now say, fine, since I'm coming into the picture now and I'm buying 20% of the share, you and Chibuzo now readjust your share. So I will now own maybe the US company now takes 20% of the Delaware company, and I and Chibuzo will now reduce our shares, and then maybe I'm now taking I think sorry, my math so I'm taking I'll be taking 20%, and if you were to lose 10%, that's not correct mathematics, but that's just a rough way to let you know what happened. So in doing that now, the foreign funder, the venture capital who is funding us now, knows that, look, this company is registered in the US, so the profit sharing is going to be done from the US, and so he avoids some of the problems that Nigerian law has, and because our company law is not very attractive, it's not well structured, unlike the Delaware company. So the flip there just simply means that it's just like you are flipping. So you are moving the shareholding from your Nigerian company to your US company, and then ensuring that, as far as the corporate structure is concerned now, the parent company becomes that company in the US in Delaware, and the Nigerian company is just the operating company in the Nigerian jurisdiction. So I'm sure you can see now why a foreign investor would prefer that, because sometimes it just exactly the law in the US is a little bit more stable. Foreign exchange issues and so many other issues could be the reason why he's taking that option of insisting that the company should be registered in Delaware. So of course there could be a number of reasons why, and I've mentioned some of them: to attract investment from private equity and venture capitalists, to open new pathways for collaboration with international partners. So international partners, some is not, their problem is just simply that they are just not comfortable operating under Nigerian law. They don't want to, ban my Nigerian courts, because they are afraid that, look, we'll come to Nigerian law now, tomorrow EFCC will wake up and just come and arrest everybody in the company. So please, we want to be bound by US law. So we don't want to deal with you as a Nigerian company. Come and incorporate your company in the US. We enter a contract with your US company. Your US company can now come to Nigeria and operate in Nigeria, but we don't want to come and be shareholders or directors of a Nigerian company. Also, it could be to expand your market to the US or to other foreign jurisdictions. Sometimes it could just be for the prestige, just so that you can carry your shoulder and say, look, my company has a parent company from the US. We are based in the US, and that also could give you some mileage and some social capital. So a Delaware flip could also bring tax advantages if you structure it properly, because part of the Delaware law allows some level of some tax relief. So for instance, if the Delaware law allows you to designate that your company is a non-resident company, though registered in Delaware, but not resident, not operating in Delaware. So because of that, there's certain tax you are not paying. So I mean, it could be. I'll just give a very rough example of how this tax advantage can work now, just to give us an idea. So for instance, EMP Nigeria Limited now, under Nigerian law, Nigerian tax rate is 30%. So if EMP Nigeria Limited makes 100 million in a year, you are going to give FRS 30 million and you are walking away with 70 million. So one way you could use a Delaware flip to benefit your tax position is this. Since the Delaware company now owns 100% of the Nigerian company, and the Delaware company is non-resident in Nigeria, if the Delaware company is the one who receives this whole 100 million, now this is just a rough example. I mean, it doesn't work this way in practical terms because there are many rules that will catch you if you try to do what I'm saying now. But assuming it was a Delaware company who is registered, who operates the Nigerian business and makes this 100 million now, because you are not resident in Delaware, you're not going to be paying 30% tax. So you are ending up, in a sense, enjoying your whole 100 million. And I'll be taking, I'm not giving any 30 million to the government. Like I said, it's just a rough example. It doesn't work exactly this way, but it just gives you an idea of the possibilities of how this could work. So that's one of the tax advantages that could come. Then of course, the usual corporate vehicle when you are doing a Delaware flip would include the LLC, which is a limited liability company in the US. They have their own rules there, but it's usually used for small companies, and then it has certain advantages. But I won't bog us with some of those details. Then there's also what they call the C Corp. The C Corp, of course, is a bigger type of company, but it allows you, for instance, to list on the stock exchange in the US and in that country. So sometimes when you are seeking funds, they'll insist that you do your venture capitalists will insist that you do a C Corp so that they can, when the time comes, they can take your company to the stock exchange, sell their shares on the stock exchange, make their money and exit. So like I say, I know this is a little technical as well, but it's just good that you will have an idea that something of this nature exists, so that the next time you hear Delaware flip or you hear the company has raised money through venture capital and all, it will not sound totally strange and like Greek to you. At least you have an idea of what it is. So I don't know, any question on Delaware flip before we move on to our practical discussion session? Is anybody already thinking of doing a Delaware flip? I'm thinking it would be good to get some aggressive dollars to back up your business idea that you are setting up at the moment. So well, maybe at the end of the practical discussion session, when we do Q&A, we could take more questions on the Delaware flip. So now looking at considerations in choosing a legal structure. I want to make it practical. So what I want now is, for some people who are on board here, if you already have a business you are running or you have a business idea, can you bring up your idea? Let's use it as a case study and then use these considerations to now ask ourselves, what is the best structure for your business? So let's get one volunteer. Any volunteer, one volunteer, let's use your business as a test case to actually discuss this. It doesn't even have to be a business you're already running. It's just, you can, even if an idea or even just something you are still thinking of in your mind, but we just want to use, use the practical discussion session to really look at how these things play out and work in actual practice. So any volunteers, or I'll just look and call anybody whose name I see here. So I see Farida Yakubu. Farida?
Yes, sir.
Yeah, so do you have a business you're already looking at doing, or you're already into business, or what?
Yes.
Okay, so what kind of business are you into? What's the nature of the business?
It's food. I make tamba mix. There's this grain they call tamba, that's I think finger millet. I grind
Okay.
it into powder, and then I put some ingredients inside, make it like ton brown. I don't know if you're familiar with
Is
ton brown.
that like kunu samia?
Yes, something like that in that nature. Yes.
Okay,
So I make, but mine is tamba mix. I do the ton brown too, and I do this potato flour.
Oh,
so
good.
mostly it's just food. Yes, in flour.
Food, okay.
Yes.
So the food business. Okay. So
yes.
So from the nature of your business,
Yeah.
now we'll now begin to look at different things and then ask questions, and then let's see what would be the best. The best. So from the current stage of your business now, the first thing we should be looking at is one of the factors you should have in mind when choosing a legal structure is the cost of establishment and ongoing corporate governance. So how much do you think you'll be willing to commit into establishing your business in terms of registering the business and getting the business to run? Like how much roughly is your rough idea of what the business or what you have already invested to get a business set up to run? Just rough ballpark. 1 million,
like how
2
much
million.
money? Okay, yeah.
Like how much money? Yes.
Basically, it's not. Sorry, come again with your question. Are you saying how much I would spend to get it out there, or how much I have spent?
Let's say how much you need to spend to get it really established, run. In terms of, I'm saying things like how much you are willing to pay to register the business, how much you are willing to.
So let's say ₦1 million.
₦1 million. Good. Okay, so that's a good point. So now let's use that now as a practical scenario to now look at the different business types. Now, like I told you, a business name is a very flexible, simple, easy to establish corporate vehicle. Because with a business name, all you need to do is just to go to CSE and register that business name. The cost of business name registration, varies, but roughly it comes to anywhere around 20,000, 30,000, maybe in the extreme 50,000 naira for the registration cost. Now, there's no law that insists on setting minimum requirements like you don't need to appoint a director, you don't need to appoint a company secretary, and all of that. So that's one level of business form. On that level of business form, let's look at companies, for instance. Now, if you want to incorporate a company, the company needs to have a share capital. And what you pay to the government for registering the company is dependent on the amount of your share capital. So if your share capital is 1 million, for instance, you would roughly be spending somewhere in the region of 80,000 naira to register a 1 million share capital company. If you are registering, and then roughly for every 1 million of increase, you may spend somewhere around on that 30 to 40,000 naira. So assuming you are doing a 10 million share capital company, you expect to be spending somewhere around 250 to 300,000 naira, and it keeps increasing that way. And of course, it also depends on other factors. If you want to do a public company, for instance, and you want to list on the stock exchange, then you should be, you are going to be paying lawyers, you are going to be paying people we call reporting accountants, you are going to be paying the trustees, the custodian, all kinds of people you are going to pay. So for instance, taking a company public in Nigeria, if you don't have anywhere in the region of maybe 50 to 100 million to spend on just that process alone, that's not to run your business. So just what you are spending on paying lawyers and paying all those people and all the cost it will incur to just establish the business alone is already close to 100 million. And then of course, with companies also, the ongoing corporate governance, you need to have, if you are a company, you have to have a director, but if you are a business, you don't need to have a director. So with this at the back of your mind now, Farida, if I ask you now, which of these structures do you think you should be choosing now, with the fact that you want to spend maximum of, say, of ₦1 million to set up business, which do you think you should be choosing?
So which would I be choosing between
So the business name that your total expenditure to establish it would be, maybe a business name, our total expenditure to establish the business name will be 100,000, it will be 50,000 naira, or a limited company of 1 million share capital that will cost you 80,000 naira, or you want to do a public company so that you can ask members of the public to come and buy shares in your company that will cost you 50 million naira. So which would you be going for? I'm just saying in the ideal scenario, I'm thinking of the cost implication now. And you are looking at ₦1 million total expenditure, including both the money you are going to use to establish the business and the money you are going to use for your take-off capital. Which of these ones do you think you should be going for? Should you be doing a company for 80,000 naira, or a business thing for, let's say, 30,000 naira, or a public company for 50 million naira? Which should you be going for?
I think I will go for a company.
Okay, good. Okay, excellent, good answer. Because, and why your answer is right is because there are other things to consider also. It's not just about the fact that business name is the cheapest. Therefore, I should go for business name.
Yeah.
Okay, so just to bring others into a conversation, does anyone else have a different opinion? Putting yourself in Farida's shoe, will you rather go for business name 30,000 naira, or will you rather go for public company 50 million naira? You know, any other person, if you're assuming you're in Farida's shoe, you are like that, don't take 8 million naira for a 1 million capital company. Take 50,000 naira, take 30,000 naira for business, or take 50 million for public company. Any other person just like to give us another context? So, Ifeoma, let's hear from you. What do you think? Would you advise Farida differently, or you go with the choice she has made?
Sorry, sir, what's the question?
Yeah, so okay, so I'm saying Farida has said, considering the cost implication, which is the first point of the considerations for choosing a legal form. We say the cost of establishment and the ongoing corporate governance. So I said the cost of establishing a business is the cost of establishing a limited company is 1 million. Is 1 million naira. The cost of establishing a public company is 50 million naira. And Farida's business is a food business. She's doing something that is, you know, a food product essentially. She's thinking that total spend that she wants to spend on both startup capital, establishment cost, and all is 1 million naira. So we're saying, if you were in her shoes, which option will you take?
Okay, the one that you want will spend less on.
Yeah, so do you prefer business by 30,000 naira on?
Yes, the one that will spend less on and still maximize profit.
So you can maximize. So I can use the rest of the money to raise capital, to buy more guinea corn, to produce more products, right?
Yes, sir. Yes, sir. Okay.
So it's good. So you see what this is doing for us now is to now show that, okay, there's one metric we already have on the table. The cost of the establishment of some business forms are cheaper than others. So typically, you would want to go for the one that the cost you are going to put into establishing it. And when we say cost of establishment now, that's excluding the money you have to use to now run the business, in terms of the money to buy raw materials and all of that. So we have agreed that it is better to go for the cheaper forms, a business name. But now, when we begin to look at other considerations, you might now find that even though a business name is the cheapest, and what you go for, you now find out that if there are other factors involved, maybe it may not be wise to go for business name. So let's look at another factor, still using Farida's food business as a test case. Yeah. So let me go to the next, and I'll try to now bring another thing into the mix and ask another person's opinion. So now, for tax purposes, a business name is taxed as an individual. That means if you are running, if Farida is running, so let's for purpose just say Farida Foods as a business name, which is what Ikongbeh has advised. So let's assume we take Ikongbeh's advice and say, run Farida Foods as a business name. Pay 30,000 naira to incorporate it. You have the rest of your 970,000 naira to, out of your 1 million startup capital to now flow into the business proper. But however, because the law views a business name for tax purposes as not different from the owner of the business, because remember what we said, that a business name does not have limited liability, is not a separate person in law. Therefore, when it comes to tax purposes, when the law looks at Farida Foods, it is looking at Farida. It doesn't see Farida Foods as a different entity from Farida. So it is going to charge tax at personal income tax rate, which is roughly around 21%. So it means that if Farida Foods uses that 930,000 naira to do business, and at the end of year one, makes a total profit of 2 million naira, the government is going to collect 1% as tax because Farida Foods is a business name. But assuming Farida Foods was incorporated as a company, whether a 1 million share capital company or a public company of 50 million naira, Farida Foods will be paying 30% on.
Please, can you?
Okay.
Hello?
Yeah, hello. So can you hear me now?
Yes, I didn't get what you said for the business name.
Yes, so I say for a business name now.
Yes.
Remember, I mentioned that a business name does not have separate legal personality. Do you understand what that means?
Yes.
So that means when the tax master comes to collect tax in Farida Foods, he will not be looking at it that Farida Food is different, Farida Yakubu is different. So he will not give you two tax assessment. So you will not be paying a different tax as Farida Yakubu and paying a different tax as Farida Foods. You'll be paying one tax, and that tax is 21%. But if you register it as Farida Foods Limited, when the taxman comes, he will say, Farida Yakubu, go and pay personal income tax as a person different. Farida Foods Limited, pay another tax because you are a different, in the far as law is concerned, Farida Foods Limited is different from Farida Yakubu, the human being. So you'll be paying tax in two places. So you can imagine now that, assuming at the end of year one, Farida Foods made a profit of 10 million. If Farida Foods is a business name, Farida Foods will pay tax of 2.1 million naira. But if Farida Foods Limited is registered as a limited company, we paying tax of 30%, which will be 3 million naira. So you can also see that in looking at our second criteria, it is still telling us that it is wiser to select business name, because with business name you are paying less tax. Can you see that there's an advantage in selecting business name? Yeah. If we take the second factor into consideration. So I hope you can see that. So I hope everybody can see that looking at tax purposes now, will you still stick with the firma and advise Farida to say, Farida, go for a business name? Because if you take limited company, you are paying more tax and you're also spending more money at the point of incorporating the business. So do we all agree with that? So I would ask Richard Jeremiah, do you agree with that? Would that be a good advice to give Farida? Richard? Okay, or let's look for someone else. Gladys? And anyone else can jump in, please, even if I don't call your name. Just jump in if you know, what do you think about this? Is it a good idea to tell her to stick with business? Tax rate is lower. Anyone? Wonder Gold.
Okay, so on this taxation,
yes,
considering the type of business, what if I don't want to, with this scale of business now, the 1 million naira establishment cost, if I don't want to do business name because of that scale, in terms of taxation, what if I reason that because I might have staff and they themselves would have to pay taxes? Okay, so I want to know, first of all, those taxes they will pay, will it be included in the company tax, or do they pay taxes for themselves? I don't know if you understand.
Yeah, I get that. So if it's a business name, all your employees will pay their tax separate. But you, the owner of the business, will pay one tax, both for the business and for your personal tax. It will all be rolled up together. Yes.
So the employees now, the tax they will pay, is it inclusive, as in, is it part of the 30% the company is paying?
Yes. So for the company, how it works now is that if the company made gross profit now, total profit of 10 million.
Yes.
You will first of all say, and all your staff salaries for the year is 5 million. You will take out that 5 million first. So, and then you take out other things. So it is what is left now that will be profit after, that will now be the profit before tax. So after you have removed your staff salaries, total staff salary of yours 5 million. So it is the 5 million that is left that you'll be paying tax on. But if it's a business name, it is not viewed that way, because the law will look at it that you are the one running the business. So the fact that you employ people and rest is all part of your internal thing. How you pay them salary or is not the law's business. They are charging you tax on your total income. So you can see that there's some back and forth there. There's tax advantage somehow. There's no tax advantage the other way.
Okay.
All right. Can you hear me?
Yeah, I can hear you. Yeah. Okay, is that Richard? Yes.
Yes. Now, particularly on this tax issue. Yes, I actually discovered that outside Nigeria, you pay for your tax exclusively. Like now, but there are some companies in Nigeria that in their transactions, they charge for value that added tax. Like where does that go to? Where does that channel to?
Okay, yeah. So value added tax is another type of tax. What just so I don't complicate too much, what value added tax simply means is that, and this is just a very basic way of saying it, the Nigerian government is saying that, look, for every product you consume in Nigeria, value was added to that product because the Nigerian government has kept a stable country where you can enjoy goods and services in peace. Therefore, every goods and service you consume, pay extra 7.5% of what it costs you to buy to the government as a tax for value addition, because the government, by having an armed forces, having police, building roads, maintaining the country's border, is creating a conducive environment for you to be able to enjoy. So when you buy that phone that you are going to enjoy, in addition to paying the 100,000 you bought the phone, pay another 7,500 to the government as a value added tax, because the government has added value to the system.
Sorry, can I come in? Sorry for the interruption.
Yes.
All right. Now, this tax is charged at the user end. Now, I'm speaking from the business perspective. Like there are some businesses that even accept the 7.5 as part of the transaction. So, like, where is that settled? Is that settled as well, like with the in addition to the personal income tax? Or
yes, it is, because these are different tax. These are different type of tax. So one company will pay VAT. After paying VAT, you will still pay what they call company's income tax, which is 30% of your profit. After you pay that, you still pay what they call education. I think it's a tertiary education trust fund tax, which is 2%. So there are different types of tax that one business is paying, because they are all aimed at different types of economic activity. But I think the take home we are getting here now is that when you are selecting the type of business structure you want to run, now you have to consider the issue of tax. Because if you pick, and so far we are saying, using the case study of Farida Foods now, we have said that if we judge, if the only reason, the only concern we're having is the cost of establishing the business and getting it running, we would normally go for the cheapest, which is business name. We're also saying that on the second item we are considering, which is tax. Tax, if the only two things we are considering in selecting a business for Farida is cost of establishment and tax, we will still pick business name. Reason being that business names still seem to have the lowest rate of tax compared to a company. But let's now go to the third now, which is capital. So for instance, now the question I need to ask Farida is that, Farida, let's assume that this 1 million that you want to invest into the business of starting Farida Foods, assuming you have the money already by yourself, or you have a business partner who is willing to contribute 500,000, you contribute 500,000. Now that would be what we call equity financing. So both of you bring the 500,000 and you put it into the business. But this your friend that you are getting this 500,000 from is not willing to. He's saying, look, me, I'm going to put my 500,000 into this business. But however, I don't want any basic, because I'm not going to be there with you when you are doing this business. So I don't want any trouble. I want to be sure that once I put this 500,000 in, if anything happens, let them not call my name beyond this 500,000. I don't want to now hear that somebody has come to my house to seize my car because Farida Foods went bankrupt and they are owing that person 5 million naira. So if that factor came in, I want to ask anybody now, what business will you still advise Farida to pick, and her friend now, who is her partner, to still pick a business, considering what we have discussed about limited liability? What would be your advice? So any other person can jump in and from what we have discussed and tell us what would be your advice. Should Farida Foods be a business name or should it be a limited company? Considering that Farida's friend is now saying, look, I want to have limited liability. What are the options on the table? So let me go back to maybe I should go back to different business types. So we'll look at them and remember. So remember, we can have a company, we can have limited partnership, we can have limited liability partnership. We can also have social enterprise. So which will you be advising Farida, considering the limitation that the friend is bringing to the table now, saying, I don't want any basic beyond arising for me personally from this business. So Farida, your mic is unmuted. Do you want to give it a try?
Yeah, I would still stick to the company. I wouldn't do the business.
You stick to company, exactly.
Yes.
And why would you stick to company?
Because of this scenario that you pointed out.
Because of limited liability, right?
Yes, yes.
So that your friend will have that comfort of knowing that if this business goes bankrupt, nobody's going to come and bankrupt.
Yes,
so
exactly.
Business, you say no, because business name exposes her and doesn't give her limited liability.
Yes.
So which other business form can we use apart from company if this is the only consideration that your friend wants limited liability? Looking at the other business form, which other one can we use apart from company? Yes.
I think we will go for limited liability partnership.
Excellent. But why would you go for limited liability partnership? Considering that the friend is saying, Farida, you are the one running this business. Me, I'm not running this business. So I want limited liability. Which other form can we go for where Farida will still have liability, unlimited liability, while the friend has limited liability?
Okay, I think that should be a limited partnership.
Excellent, limited partnership. So I hope we are getting it now. We can see the practical consideration of how you need to keep weighing different factors. So you can see that with this scenario now, we now see that business name is no longer workable because there's somebody in the military saying, look, me, I'm not ready to take basic. So I want my liability to be limited. So that now opens us up to 3 options. We can do limited partnerships. We could also possibly do limited liability partnership. But if Farida's friend is smart, you say, no, Farida, you are the one running this business. So you should have unlimited liability so that if you be forced to run the business right, because if you have limited liability like me, you can run the business at ground, you also not incur any liability. So I hope you get that thinking. That you are saying, Farida, because you are the one running the business and you're the one who knows this business, let your liability be unlimited. That will force you to do the right thing so that the business does not go bankrupt. Because if 2 of us have limited liability, you could run the business recklessly. If it goes bankrupt, you won't be incurring liability, I won't be incurring liability as well. So I hope you can see how this is a practical consideration in negotiating your business form. So it's also possible this scenario. Yes, sorry, yes. Farida,
I don't get it. I don't get the difference between the limited partnership and the limited liability partnership.
Okay, good. So let me explain it now.
Okay.
In practical terms now. So I have come into the business with you, and 500,000 to start Farida Food. When we start Farida Food, I've given my 500,000 to you as well. You have the 1 million now. You have spent the money to establish the business. You have made in the year 1, you made profit of 2 million, and I got some profit share from that, and I was happy. But in year 2, because you are the one running the business, you now go and take a loan of 10 million and you misappropriate the loan. And because of that, the bank now comes and says, we are going to wind up Farida Food, to sell all the assets of Farida Foods to recover our 10 million. So when the bank now sells all the assets of Farida Food, maybe it sells all the containers you have, the packaging machine you have, the branding machine, the stock we have of goods you have not sold, the bank is only able to recover 5 million. So it means that, but whereas you that took the loan of that 10 million, maybe you took 5 million out of that 10 million and you bought a car for yourself. So you can see that the business has closed down. I have lost because the business closed down. You have also lost. But the bank cannot come after you and me for their balance of 5 million. But imagine if we used a limited partnership. It will mean that after the bank collects, sells all the assets of Farida Foods, and they take their 5 million, the bank can also come after you and seize your car, sell your car, and recover their 5 million. Because of that factor now, in a limited partnership, it will make you, Farida, when running the business, to be careful, because you know that if this business folds up, you will lose your personal car and your personal assets as well. But if we use limited liability partnership, I will have limited liability, you, Farida, also have limited liability. It will mean that the person who will be losing will be the bank, because the bank will not be able to get his 5 million back. So I hope you get it now. And that's the difference between limited partnership and limited liability partnership. In a limited partnership, one partner, you, who in this case will be Farida, is the general partner. So if the business goes bad, after the people sell all the assets of the business, they can come after your personal assets and also sell them. So that means you, the general partner, now, because you're the one running the business, you'll be careful to make sure the business is run well, because if it goes wrong, your own personal asset is also on the line. But in a limited partnership, I have limited partnership, you also have limited partnership. It means that as the person running the business, you may run it poorly, knowing fully well that if it goes aground, you have nothing to lose in a sense, because you know I will be losing more, you are not losing, and then the bank, of course, that gave us the loan will be losing the most. So I hope you get
that's
that.
in limited liability.
Yeah, in limited liability partnership. That's
Okay.
what happens in limited liability partnership. Because in limited liability partnership, everybody has limited liability. But in limited partnership, the general partner, that's the person who runs the business on a day-to-day basis, does not have a limited liability. So I hope you get that now.
Yeah. So in this scenario now,
yes,
the option to go for should be limited liability partnership, right?
No, it should be limited partnership. That's if your friend is wise, your friend will insist on limited partnership, because your friend will say, hello?
Yeah, I can hear you.
Yeah, so I say if your friend is wise, or if you are the one investing in somebody's business, you should be insisting on limited partnership. The reason being that since you are not running the business with the person, you want the person's own liability to be unlimited, so that the person will suffer if the business is run bad.
Okay.
You understand? While you, the investor, is protected. So I hope you get that balance.
Yes.
Okay, good.
Hello,
so
sir.
Let's look at, yes.
Hello, sir. Please,
yes.
When you are into someone with under limited partnership,
yes,
where you are the limited partner,
yes,
will you and maybe probably the business goes bad, will you still hold the general partner accountable for your own loss to pay you back, or is it just that your money has gone?
Good. That's a very good question. Now, by law, ordinarily, the partners amongst themselves can also hold each other liable. So in addition to the bank collecting their 5 million from Farida, because she ran the business account, I also, as the interparty, can also come and say, oh, having gone back cost. When I checked the books, I found out that when Farida collected a loan of 10 million, apart from misappropriating 5 million and buying a car, every time business was making money, she was also taking money out of business without, waiting for, without waiting for profit to be declared. So I can also go after her and say, in addition to the bank seizing her car, selling her car, and taking her 5 million, I can also go after her and seize her phone and sell her phone and say, look, I found out that if you have run this business well, there's another 200,000 from the business wrong that I should have my profit share, and I can also go after her. So that's why a wise person, if you are investing with somebody and you are not involved in the day-to-day running of the business, choose limited partnership. So that way, if the person misbehaves, the general partner who is running the business, if he misbehaves, you can still recover some money from it. So I hope we all get that clearly now.
Yeah, thank you, sir.
Thank you. So let's look at our next factor. So I hope we can see how these factors are all, making the choice of business form, is making us think, changing our decision. So we started with limited company. At the point we tried the business name, we have now said, okay, if this issue of capital comes in and the person is insisting, the person who is bringing capital is insisting that, look, I want safety, limited should come in. So also imagine if, so then the next now is joint ventures. So joint ventures, are a little bit, not just a regular partnership. Joint venture is where two existing businesses come together to form a new business. So assuming Farida Foods is already running as Farida Foods Limited, and I am running maybe a PR company called Everlaw Publications, and we try to now form a joint venture where I will be the one doing aggressive marketing for Farida Foods. I want to form a company on that basis. So you can see that some of the same considerations we just spoke about now is what to come into play. Because since I'm coming as a different partner, I'll now be saying, look, I want some measure of protection. So let us have a structure where maybe we set up as a limited company so that I can have limited liability. But where joint ventures are interesting is where there's now an international component, like we just spoke about, Delaware swap. So the question I'm asking is that if you have a foreign joint venture partner coming into Farida Foods, what business?
Sorry, we can't hear you.
Oh, can you hear me now?
Yes.
Okay, apologies. So I'm asking now that, assuming we have a joint venture where a foreign partner wants to now invest in Farida Foods, which business vehicle are going to be advising that advising Farida Foods to do? We advise to use a business name, a company, a limited partnership, or a limited liability partnership, which you think, considering that the foreign partner is coming from another country, and all of that, which would you advise?
I don't know this one.
You don't know this? Okay, fine. So, well, like with this one now, the whole idea is that if a foreign person is coming to a company, definitely there are many more considerations that are coming. So, for instance, a foreigner, there's a trust issue. So that foreigner will definitely not want to use a business name, because a business name, like we said, in the eyes of the law, is the same as Farida. So if you are a foreigner coming to a business, certainly you won't want the business you are investing into to be seen as one,
individual.
As an individual. So definitely you want a limited company where there are certain rules governing who can be a director. So you can appoint, a director, somebody who has the necessary business savvy, to administer the operations of the business. So typically at this point, because of the foreign interest coming into it now, you might
business name is out.
Yeah, business name is out at this point, because there's a foreigner coming into business name is out. You can see how that takes us in another direction. Now, then another factor that you need to consider in choosing a business form is control. So let's still use Farida Foods as an example. Now, assuming Farida now has now seen that this your business you are talking of, suddenly there's the Ministry of Health now puts out an advisory and says that so what do you call the name of the product again? The product you say, the one you mentioned with millet.
Damba mix.
Damba mix, good. So assuming that Ministry of Health now puts out an advisory and says that Damba mix is now encouraged, and maybe doctors now find something that Damba mix for elderly people, that Damba mix helps to re-energize them and make them turn back the years, and then suddenly people want Damba mix all over. You now find out that, look, for this purpose, I'm going to need to establish a factory that can produce the demand, or maybe Farida Food consults with Octopus, with Mr. Nelson, the consultant, who now says, look, we have found that the market for Damba mix will be 10 million sachets of Damba mix a day. So therefore, Farida now needs to set up a factory that can produce 10 million sachets of Damba mix a day. And you are going to need at least 10 billion naira to set up that factory. So you can see now that if you now need a business that needs 10 billion, what business structure would you advise for that business? Would you advise that business to use a business name? Would you advise them to use a limited partnership or a limited liability partnership or a company? What would be your advice? A company that wants to raise 10 billion. What is one of the easiest ways to raise 10 billion? You can go to the stock exchange, right? To raise 10 billion.
Okay.
Is that correct? You can raise 10 billion in the stock exchange. So imagine you want to raise 10 billion in the stock exchange now. We have already mentioned, definitely a business name cannot go to the stock exchange. I hope we all know that.
Yes.
Yeah, exactly. A limited partnership cannot go to the stock exchange. A limited liability partnership cannot go to the stock exchange. The only company that can go to the stock exchange is a public limited liability company. That's the only company that can go to the stock exchange. So you can see now that because of that capital requirement now, we are now forced to go for the option of rather taking a limited company, which we had ruled out earlier when we were talking earlier, because the cost of establishing it would be almost 50 million naira to establish it. But if the company can raise 10 billion, 50 million will not be too much of an obstacle anymore. I hope you can see how that consideration has come in.
Wait. Okay.
Yes. So are you following me?
Yes.
So I'm saying that because of the kind of money you want to raise.
Yes.
Because initially what you wanted to raise to do your business was just 1 million naira.
Yes.
But now you have suddenly found that your business can cash in on a market that needs 10 million sachets of Damba mix every day. And to be able to produce 10 million sachets every day, you need to set up a factory that will cost you 10 billion naira. So because of that, now the money you are looking for is now 10 billion. So you can see that if you are looking for 10 billion, to spend 50 million on incorporating a company will no longer be a big deal to you.
Yes.
If you are raising 10 billion, to pay tax of 30% will no longer be a big deal to you.
Yeah.
So you can see now that this will now be the reason why, rather than choose business name, you now go for a limited company. Now, remember also when we're talking about capital and joint venture, we're saying your partner who was coming in would say, no, do a limited partnership because I want Farida's liability to be unlimited. But you know, at the point where you are playing the game of 10 billion now, your problem will no longer be issue of whether Farida's liability is unlimited or not, because at that point, the company is going to go into the stock exchange. He has to have directors who are going to be operating at, you know, high-level directors. It won't just be, you know, Farida managing the business anymore. So at that point, your fear is not that Farida will mismanage the business. Now you know that, look, at the level of stock exchange, the directors are going to be directors that will be people who can manage the business. So your thinking pattern will no longer be based on, let me do limited liability partnership so that, or limited partnership, so that these directors mismanage the money, their liabilities unlimited. So you can see a new consideration has come.
Okay.
The kind of money that we are looking to raise. But I'm discussing this because what's important now is that we're talking of control factors, shareholders agreement. The reason being that if you, Farida, you start Farida Foods becomes a company of 10 billion. Now, you, the owner yourself, now there's no way out of this 10 billion, you don't have maybe more than, or maybe even plus money you raise in terms of loans to put into the capital of the business now. Maybe you don't have more than 1 billion naira. So that means you cannot get more than 10% share capital of the company. But you want to be in control of your company. Now, to still be able to be in control of your company when you don't have the financial muscle to own all the shares in the company, or to own more than 51% of the shares in the company, because you need to understand that shareholding in the company is what entitles you to have a power to vote. So if a company wants to say, let us move our headquarters from Lagos to Abuja, they will now go for a general meeting of the company and say, so everybody vote based on your shareholding. So the man who has 50% of the shares of the company, once he votes yes, let us move the company, automatically the majority, just like democracy, will have its way.
Yeah.
So it's also very important because you want to be in control of your company. You don't want to lose control of your company. So one of the ways to maintain control of your company is to have what we call a shareholders agreement.
Okay.
Remember, we also mentioned when I was discussing the different company types that another advantage of using some of these other vehicles like limited liability partnership and limited partnership is that the internal running of the company is not governed by the company law. It's governed by the private document called the partnership deed that you people sign. So if this company now, we discount, for instance, the fact that we are looking for 10 billion share capital now, if the only consideration we're thinking of was that you want to maintain control of your company, then one good way is that you may choose to say, look, I don't want to use a limited company. I want to use a limited liability partnership or a limited partnership, so that in the deed of the company, we can put that Farida will always be the managing director of this company. So we can have control. Do you get that? That because you want to be in control, you may also make you select limited liability partnership or limited partnership to allow you maintain control of the company. Because the law that will govern how the company is run will be the partnership deed, which is a document that you and your partners will sign. Unlike if you incorporate a company. If you incorporate a company, the other members of the company can wake up one day and say, we have 60% share in this company. Let us vote Farida Yakubu out. She will no longer be the managing director of this company. We want a new person to become managing director. You therefore lose control of your company. So I hope you are getting that.
Yes. Okay.
Yeah.
So does that mean that with a limited partnership or a limited liability partnership,
yes,
they can't vote me out? Even if they have more shares than I do?
Exactly, yes. Because you can write it in your partnership deed. Now, so far as this company is concerned, though, the partnership deed of this company states that Farida Yakubu must be the managing director. So whether you have 10%, 5%, 2%, they cannot remove it because the partnership deed says so. But if it is a company, company law says that majority have their way because that's company law. So you get that as well. So sometimes because of control reasons, you may choose a different corporate, you may use a different business form. Yes, Chinemere, please come in. Chinemere, you want to say something? We can't hear you, Chinemere.
Disadvantage in the limited liabilities. Can you hear me, sir?
Yes.
Hello, sir.
Yeah, I can hear you.
Can you hear me, sir?
Yes.
Hello. Disadvantage of this limited liability partnership is that you cannot sell shares now. Cannot it cannot be sold via stock market.
Excellent.
How can you be able to raise when you are considering of selling stock in the market to be able to raise the 10 billion? How can we be able to consider the two, either public limited company and then limited liability partnership in this case, since you still want to be the director?
Yes. So very good observation. So for instance now, Farida Food needs to raise that 10 billion to set up that factory. But now Farida Food now finds out that maybe who now Dangote is willing to invest 9 billion in the company. So you don't need stock exchange to raise your 10 billion. You want to just meet Dangote, meet Tony Elumelu, and all of them put money together for you to run the business. But your fear is that if you allow them bring 9 billion and all, they can wake up one day and vote you out and say you are no longer the managing director of the company. So I'm saying that in that situation where you are raising the money through those private people without having to go to the stock exchange, you can decide to use the limited liability partnership. Say, look, in this business, so by our partnership deed, I must always be the managing director, irrespective of what happens. But if it was a company you use, if you use the vehicle of a company, and those people put in that money, they can call for a board meeting and say, look, we own 90% of this company, we hereby vote you out. Because in a company, you cannot put a partnership deed because there's no provision for partnership deed in a company that overrides. The only thing you have in the company is what I mentioned there, which is shareholders agreement. The shareholders agreement can allow you have some level of control, but shareholders agreement cannot make you contradict the law that is in the Company and Allied Matters Act. So the law in the Company and Allied Matters Act is clear. Directors cannot perpetuate themselves in office. As a director, you cannot decide that nobody can remove me as a director, that I must remain a director. So far as you choose to use a company, because that's the law, your shareholders agreement cannot change that law. But if you are using a limited liability partnership, the law allows you, let your partnership say anything you want to say. So therefore, if you are looking at setting up a corporate structure where your partners are bringing a lot of the money, you are not bringing a lot of money, and you want to protect yourself, then you might think of using a limited liability partnership to make sure that you can write in some protection for yourself in your partnership deed that you cannot write into your shareholders agreement if you are using a company. So you can see where this scenario plays out. But if the scenario was that you are going to the stock exchange, then you don't have an option, because once you take the money of people on the stock exchange, you cannot now say, of course, in the first place, like you said, Chinemen rightly, a limited liability partnership cannot sell shares on the stock exchange. So you can't even approach stock exchange if you are using limited liability partnership. But this is just showing you the different scenarios and what we can use in any of those different scenarios. So then the next point is closely allied to what you just mentioned, which is anti-dilution. So anti-dilution simply arises from the fact that a company grows in value, and also the company can increase the shares and issue more shares. So if we incorporated Farida Foods with a share capital of 1 million, and it was in the course of running the business that Farida now discovered that every time she produces the Damba mix, before she even finished producing it, people are already waiting to buy up all the supply. And it was based on that she now approached Octopus, says, look, do come and consult us and do a market analysis for us and tell us what the demand for our Damba mix is in the market. So we're operating as a 1 million share capital company. And at that point, based on the analysis report from Octopus, we now found out that, look, we can sell up to 10 million units of Damba mix every day. And based on that, we now established the 10 billion naira factory. Now, the company was originally had the 1 million share capital. Now the value of the company has increased, having now owned a plant that is worth 10 billion. So the new value of the company is now maybe 15 billion. So at that point, what you do in CS is that you increase the share capital of the company. So at the share, instead of share capital being 1 million, it's now 10 billion. So when the share capital becomes 10 billion, it means that they are, and that's how you now take those shares to the stock exchange to sell them so people can buy those shares. So in the course of buying those shares, what it means is that when the company used to be 1 million share capital, Farida owned 50% of the company, 500,000. Her partner at the time, which maybe is me, owned 50%, 500,000. But the moment the company becomes 10 billion, our 500,000 is no longer 50%. Our 500,000 becomes maybe 0.0005%. So you can say that our shareholding has been diluted. So dilution is also a factor of control, because you don't want your shares to be diluted to a point where, because the shareholding percentage is what gives you the right to vote. Like I mentioned, that the fact that Dangote now owns 90% of the company means that he can vote to remove you as a director. So when we talk of control factors, we also talk of anti-dilution. So you want to put in provisions. You want to run a kind of, if you are going to run your business as a company, then you need to put in those, anti-dilution provisions. And like I've mentioned, in choosing the legal form for your business, you consider that, okay, if I choose a company, for instance, and the company's value begins to go up, my shareholding will be diluted. But if I choose limited partnership or limited liability partnership, which is what I just discussed before, then I could put anti-dilution provisions in the partnership deed and prevent my control from being diluted. So control factors and dilution are actually together, as it were, and I should have discussed them together, but they are just two sides of the same coin, essentially. So these are also factors you choose. In the course of designing your corporate form, you need to consider that and ask yourself, I don't want my shareholding to be diluted too much. Then, of course, pricing and valuation is another factor you consider when you are deciding what type of form. So if you are going to have a company that is going to be worth 10 billion, I mean, you can't be thinking of doing business because it won't even make sense. And even in doing a company, even in selecting a company, you also may prompt you to select a public company rather than selecting a private company because of the value of the company. So this is also another factor is already wrapped up in what I had already discussed earlier. So you can see that the valuation of what you are going to go into. But if you are going to just do a small business, we just want to be, doing small water business, just do water bottle and sell and all. You might want to use maybe a limited liability partnership and all, but based on the value, it will also determine what kind of corporate form you use. Then the final, another final consideration you need to have in mind is what we call vesting, or ESOP, that's employee stock options. Now, imagine that when Farida was starting this company, Farida has a staff who knows how to do the blend for her Damba mix come out very well. Now, that staff does not have money to buy shares in the company when Farida is raising 1 million to start the company. But Farida knows that if that staff leaves her, he can go and set up a competing company or work for a competitor, and he knows how to, there's a skill he has that is vital to the company. And you want to retain him in the company. You don't want him to leave the company. Now, one of the ways you can do is what we call vesting. Vesting simply is a structure where you say, look, you are my employee. You don't have money to bring capital to the table. But I'm willing to say, if you will stay with me for 4 years, I will give you 10% of the shares of the company, if you will stay loyal with the company for the next 4 years. And this 10% would vest. Vest simply means that the 10% is yours potentially, but you have to wait until the end of 4 years before that share is vested in you. That means the share becomes available for you to begin to benefit from it. So you can decide to now vest it in a staggered way to say, for every year that you stay, you get 2.5%. So after 4 years, you get a total of 10% of the shares. So vesting also is something that you can use companies to do. So if you are now thinking of that type of key employee that you want to retain, it means you cannot use business name, you cannot use limited liability partnership, you cannot use that method. You have to use a company if you want to be able to have an employee stock option. So you can see how this also becomes a consideration that will make you decide how you want to structure your business. So at this point, I see we are almost running out of time. So we'll take general questions and then we'll just quickly look through the Q&A that I had set, just to see how we have really imbibed some of this lesson. So any questions, any observations, any comments?
Yes. So my question, how can you tell the difference between a company, the limited liability partnership and the limited partnership?
No, so it's a choice you make essentially. It's you who is deciding that, having found out that my business is going to, for instance, want to retain some key employees. Therefore, I need to use a company because only a company allows me.
Hello? Hello?
I can hear you, Farida. I think his network may be
okay.
erratic.
Yeah, sorry. Can you hear me now?
Yes.
My apologies. My power went off again, so I had to change power source. Okay. Yeah, so I was saying essentially, Farida, that it is you who is considering all these factors and making up your mind which type of structure you want to give your business. So it is when you consider all of this, you make up your mind and say, look, I want to make my business a company because I want to go to the stock exchange, or I want to make my business a limited liability partnership because I want to be in control. I don't want to lose control of my business. So you are the one who now looks at all these factors and makes up your mind which type of structure you want to give your business.
Okay. So another question, please. What's public company about? Like, I didn't get that. A public company.
So essentially, so public companies are companies that are allowed to sell their shares to members of the public and use it to raise money. So if you
like
do
MTN?
Like MTN, exactly, like MTN, yes, like Dangote Cement. Yes, like First Bank Group, First Bank Holdings, sorry. So the reason is that why those companies have advantage is that they can sell their shares to anybody. So it means they can get money from more sources. But if you're a private company, you can only sell your shares to private people. So and you have to start looking for people to buy shares. But Imagine if you go on the stock exchange, you put in newspaper advert, Farida Foods is selling 3 billion ordinary shares at ₦1 each. So anybody anywhere in Sokoto can buy, another person in Calabar will buy, somebody in Lagos will buy, anybody anywhere can buy. So that means you are able to get more money from more sources than a private company.
So that's like the only advantage?
Yeah, that's about the only advantage, yes. Your access, essentially your capacity to be able to raise funds. And then sometimes also, it's also a prestige thing. There's the fact that a public company also tells people who are dealing with you that you are a more organized company, because to be a public company, like I said, to start up alone, you have to spend 50 million. So it means that if Farida Foods Limited goes to bid for a contract with EMP PLC, people say EMP PLC is a bigger company, because for them to have 50 million to even register a company, it means they will be more serious than Farida Foods, that's just a small limited company. So there's also a prestige element to the fact that.
So another question, sorry, I think I'm interested in this part of the lecture.
Yes.
So I'm taking you back to joint ventures and partnerships. Like, can a business name be registered, come into a joint ventures with a company? Is it possible?
Well, not yes. It's possible that a business name. So, for instance, Farida Foods business name and an EMP Limited can form a joint venture and call it EMP Farida Limited. That's in a sense possible. But from the viewpoint of the law, because the law views Farida Foods business name and Farida Yakubu as one and the same person, it will in effect mean that it is Farida Yakubu and EMP Limited that are doing that joint venture. That's what it would mean. But usually why joint ventures are important. Typically,
you guys making out to talk, but I will tell your grandmother.
Okay.
Thank you.
Sorry. Okay, yeah. So thank you, Farida. So any other? So I just have a few questions. I'll run through them like multiple choice questions. I'll just read them out quickly and let's just try to answer them just to help jogger. So the first question I say, 4 options. What is law? A set of binding principles. B, binding standards of conduct. C, prescriptions of elders based on experience. And D, set of standards to ensure good conduct. Did everybody get the question?
Are we supposed to answer that?
Yes, so anybody can just randomly answer. And then, so what is law? Okay, so I can see, Stephen, please carry on. So what is law? Yeah, Stephen, please, you can unmute.
Can we see the question with the options again?
Okay, unfortunately, I couldn't type them up. Okay, so let me read it again. What is law?
Okay.
A set of binding principles. B, binding standards of conduct. C, prescriptions of elders based on experience. And D, set of standards to ensure good conduct.
D, set of standards to ensure good conduct.
Okay. Anybody has a different opinion? Anybody has
B.
Yes. B, binding standards of conduct. Okay, well, any other person has a different opinion? Anybody has a different opinion? We also have on the table a set of
You're breaking, we can't hear you.
And prescriptions of experience. Oh, sorry, can you hear me now?
Yeah.
Can you hear me now?
Yes.
Okay. So I said the options we have 2 other options left. We say, is law a set of binding principles, or is law a prescription of elders based on experience? Does anybody think that that is the correct answer to what is law? So Farida has told us it's a set of standards to ensure good conduct, and Chinemerem has said it's a binding standards of conduct.
Can we choose more than one answer?
Yes, you can.
So I'll go for A again.
A set of binding principles. That's a set of binding principles.
Yeah.
Okay. So yes, Stephen, we can go on, please. Amua, Stephen. We can't hear you, Stephen. Okay. Hello?
Can you hear me now, sir?
Yeah, we can hear you now. Yes, please.
Yeah. Well done, sir. So I want to know more about the issue of commercial papers.
Okay.
Whereby companies use commercial papers to raise.
Issue commercial papers.
Yeah, to raise funds. I want to ask: do you have to be a limited liability company or a public company before you can use use the commercial paper?
What is
when it comes to commercial papers, there are two aspects to it now. Now, technically, any company can issue commercial papers, but what is now important is whether you can sell that commercial papers on the stock exchange or you can sell it to the consuming public, as a security. Now, for your investment papers to operate as securities, you have to fulfill certain requirements, of which SEC will first of all ask you that your company must be a limited company, or it must be a PLC, and then so many other requirements. So if you are not going, and then of course it's even actually illegal to issue commercial papers without approval of SEC. So at the point of your getting, can you hear me?
Approval of what? Sorry, I didn't hear that.
Of SEC, okay, SEC, that's Securities and Exchange Commission.
Okay.
So to issue commercial papers, because commercial papers are considered to be securities. When we call them securities, that just simply means these are special investment documents that have to be approved by the Securities and Exchange Commission before you can sell them. So definitely to sell commercial papers, you have to meet some requirements from SEC. So that includes being a company, being registered. You have to show evidence that you have been properly audited. You have auditors, plenty requirements. Your directors have to be proper people and all of that. So there are lots of requirements to be able to issue commercial papers. It's almost as high as being able to list on the stock exchange and sell shares to the members of the public. It's almost at that same level. Okay, so for sake of time, so yeah, so question one, so the answer actually is B. So Chinemere was right. So law is not A says a set of binding principles. It's not exactly a set of binding principles because it's not just about principles. It's about standards that have been agreed upon. So standards of conduct is the key word there. And it has to be binding. It's also not a prescription of elders based on experience, because that can be morality, but that's not law. It's also not a set of standards to ensure good conduct, because it's a little beyond just ensuring good conduct. Morality ensures good conduct, religion ensures good conduct, but the law has a binding force that, and it's a standard of conduct that has been agreed and has that binding force from the government. So yeah, Richard.
Yes.
So Richard, I see your hand is up. Yes.
Can you hear me?
Yes, please.
All right. So about raising funds like through equity, is there any particular way one can raise funds through equity without losing, I would say active ownership of the company? Because like now, let's assume the company is evaluated at 20, let's say 20 million naira, and
yes.
I want to get money from an investor. Someone wants to invest, and the person said is giving me 2 million naira for a proportion of 10%. So, and I feel like if I'm giving him that 10% at that particular time, it's not like the 2 million naira will be the one to solve my problem, like my active problem. So how can one solve that again?
Okay, so there are a variety of measures to retain your control even while getting money from third parties. One, the quickest and the easiest is to get debt equity rather than to get debt financing rather than equity. So instead of getting people to invest and buy shares in your company, which now makes them co-owners of your company and dilutes your control and brings this control issues. You can say, instead, give me the money as a loan. So you're not getting any share in my company. When I go do the business and it succeeds, I pay you back your loan. That's the easiest of ways to ensure that you're getting external financing, so you don't have any control issue or any dilution issue. But of course, that always will not always work. So if you must take on funds in, one way, like I've mentioned, is you can use a limited partnership or a limited liability partnership, drop a partnership deed and make yourself the irremovable general partner. That's also another way. Another way, if you're using a company, to have a shareholder agreement that says, look, even if my shareholding is only 5% of the company, you cannot do X, Y, Z except I agree. So you cannot change the name of the company. You cannot change the business, the line of business of the company. You cannot, do certain things. You cannot appoint a director without me agreeing to it. So you can also do that in a shareholders agreement as well. But what you cannot do by law is to now make yourself a director and you can never be removed as a director. The company law will not allow that. So that those are some of the places where, but there are other ways to think out control. So I hope Jerry got that.
Yes, I did. Of course, I did.
Okay. Can I comment a bit?
Yes, please.
Thank you very much, Jerry, for that question. We're going to have a session. I'll be the one handling that session on risk equity financing. In other words, how do you structure to raise equity without losing control? It's a whole course. It's a whole cost itself. And part of this is why we are laying this very good foundation. Because Barrister Marx will still talk about, Barrister Marx, maybe because of that question, it might be good to just discuss maybe in the next lecture, because today is already gone, ordinary shares, preferred shares, and the behaviors like participating, non-participating, shares, so that these are the shares that's the instrument you use eventually for crafting a system that gives you control even when you are raising money. Thank you.
Yeah, thank you. That's actually very important. Yeah, so I agree. I'll onboard that for our next session, and we'll kick off with that actually to look at the types of shares, look at the rights attaching to shares, and the features of the different types of shares, and then touch a little, of course, without going into the depth of risk equity financing, which, like you have said, is a huge area and it's very important for you to understand that, because at every point in time, if you are forming a company and like the word company suggests, you have to bring other people on board. So if you don't understand these fundamentals, then you might find yourself in trouble that you finish toiling and building, and then people just come and take the benefits because you have, because you have allowed their money to come into the business. Because you cannot allow their money in without allowing their voice to enter. So there's a whole syllabus on how to do that without burning your fingers. Okay, so the next question I have is, which of the following business form lacks any possibility of limited liability? That means which of the following business form can you never be able to get limited liability? I hope you get that question. So the options are A, company, B, business name, C, limited partnership, D, limited liability partnership. So which of these ones will you never be able to get limited liability? That they can always sell your car and your house if the business goes bankrupt. Who wants to take on this question?
The business. A.
Business name.
Business name, yeah.
Okay, good. Anybody has a different opinion? Okay, so I guess that's straightforward and easy enough. So business name, that's where you never get any type of limited liability. Then the third question, which of the following is false about social enterprise? So I know I've abandoned social enterprise, but I saw Odun, we are coming back to you now. Which of the following is false about social enterprise? A, they can exist as company limited by guarantee. B, they can share some income, e.g., they can pay honorarium or salaries to the founder. C, they can exist as incorporated trustee. And D, they are not allowed to make profit at all since they are non-profit.
D.
They
are not allowed to make profit at all.
At all. Okay, yeah. So let's hear from others. Odun, I know this is your area, so let's hear from you. Non-profit, a social enterprise. Sorry. Okay, seems is Odun in a meeting at all? Oh, it seems maybe she fell out at some point. Okay, so anybody has a different opinion from that? From D. So I guess that's straightforward. D is it. So, like we said, the law does not prohibit social enterprises from making profit. What it prohibits them from doing is sharing profit. So they can't share profit, but they can make profit.
How? Share profit how? I don't understand.
Okay, so the way businesses run is that
yes,
you trade in a year. At the end of the year, you now put all your income on one side and say, oh, this year we sold 3 million sachets of Dambu mix. We made 100 million. But our expenses, we bought raw materials, 50 million. We paid staff salary, 20 million. So at the end of the day, our profit, so at the end of the day, we spent 70 million as expenses. So our profit is 30 million. So on that 30 million, we have paid tax to government. So we have 20 million left. So that 20 million left now, Farida owns 500% of Farida Foods Limited. So you get half of that 20 million, 10 million will be shared to you as your profit share, or what we call dividend at the end of the year. And I also have 50% of the company. I also get 50% of that also another 10 million. So you understand, that's how we share profit at the end of the year. But for social enterprises, they cannot sit down and share the money like that because they are set up to achieve a social cost, which is the reason why government did not collect tax from them. So if they make any profit, they have to use that profit to now fulfill their objective. So if it's to give scholarship to students, there is that money to give scholarship to students. But they can, however, pay salaries, they can pay honorarium, they can pay sitting allowance, but they cannot share the money. And me and Nelson say, since we are around that funded Heart and Art Foundation, and at the end of the year, Heart and Art Foundation, got 10 million grant, and also let's share, and we have done the projects, 7 million, there's 3 million left, let's share the 3 million. No, you can't do that. So I hope you get that clear, Farida.
Yes, thank you.
Okay, yeah. So then the fourth question, one of these reasons is not correct for the choice of doing a Delaware flip. Remember I mentioned the Delaware flip. So one of this is not the reason why you do a Delaware flip. Number one, tax savings. Number two, prestige of being a US registered company. Number three, that's C, sorry, evading FRS tax obligation. And D, attracting venture capital. So which of this is not the reason why you do a Delaware flip?
C.
Evading. So I think that's simple and straightforward. Exactly. Yeah. So you do the Delaware flip because you want to have tax savings. You can do it because you want prestige of being a US registered company. You can do it because you want to attract venture capital, but you cannot do it because you want to evade tax obligation, because that's a criminal offense. Then number 5, one of the following is not relevant in choosing a business structure. So we have mentioned some of the things we consider in choosing a business structure. So one of these is not relevant. So taxation, B, control, C, foreign partners, and D, foreign languages of the partners.
I didn't get the question.
So that's simple and easy, right? So we said one of the following is not relevant. Foreign language is good. Excellent. So the things that are relevant, taxation, you have to consider, like we said, consider your tax. It will tell you which type of structure you want to use. Issue of control, very important. If you have a foreign partner, also could be a factor on how you structure you might not want to use a business name if there's a foreign partner involved. In fact, as a matter of fact, by law, if your foreign partner cannot be a partner on that business name like that, you have to do a company. Then number 6, which of the following sounds least like a business law issue? Remember we talked about what business law is. So which of the following sounds least like a business law issue? Number 1, refunds policy. Number 2, police arresting your delivery truck driver during a business delivery. C, arrest of business manager. I hope you can still hear me.
No, we can't hear you.
Okay, so I said, which of the following sounds least like a business law issue? A, refunds policy. That's your policy on refunds. How customers refund, because it needs to be an agreement on that. 2, police arresting. Oh, sorry, somebody's mic is on. Huh?
Yes, I can't hear.
What mic is that? I think it's Chinemerem.
Sorry, sir.
Okay. Yes. So which of the following sounds least like a business law issue? Refund policy, because refund policy is issue of law. So how people refund items, maybe for instance, Dambu mix that they buy. 2, police arresting a delivery truck driver of your eatery during business delivery. He's delivering food to customers and police arresting. Maybe for wrong parking. C, arrest of a business manager for beating up a subordinate at a beer parlor after work hours. And D, theft of company trade secrets by an ex-employee. We'll talk about intellectual property later, but trade secrets is just like intellectual property. So somebody steals, for instance, the unique mix that they used to do the Dambu mix, the unique formula to do the Dambu mix that gives it its unique taste. Somebody steals it. One of your employees steals it. So which of these sounds less?
A,
refunds policy. Anybody thinks differently from refund policy?
I didn't get the question, man.
Okay, let me repeat the question again. Which of the following sounds least like a business law issue? Remember, we mentioned that business law involves those issues of law that normally arise in the course of business. So we say, which of these is the least sounds least like a business law issue? Refunds policy. A. B, police arresting your delivery truck driver who is delivering food in the course of a business delivery. C, arrest of a business manager for beating up a subordinate at a beer parlor after work hours. And D, theft of company trade secrets by an ex-employee. So
I think
C.
Arrest of business manager.
C. Yes.
C. Arrest of business manager for beating up subordinate at beer parlor.
Yes.
Okay, good. So good, yeah. So you guys got that. Because a refunds policy is an issue of law because the contract, it's part of the contract, and which is the next topic we are taking, contract law. So refund policy is a contract law issue. Police arresting your driver because of wrong parking when he's doing a business delivery. Though it's a criminal issue, but it impacts on your business because that's something that's going to disrupt your business. But 2 people going to fight at the beer parlor after work hours, that's their personal issue. Exactly, after work hours, that's their personal issue. If they fought in the business, maybe it involves some need for your business to get involved in resolving that issue. Theft of company trade secrets, even though it's a crime, is also an issue of business law because how you manage and protect your trade secrets is a very important issue in business law as well. So the last question. Yes.
Hello, sir.
Yes,
please. On this last question, even though that we know that fighting, some companies, I think they don't take fighting in public place.
True.
It's basically, most of the companies basically against their policies in the company, like in the banking sector, You
are correct about that there could be some link, because when it comes to law, everything is kind of linked. That's why the question was the least like a business law issue. So the least amongst the others. The others are more urgent to, they are more connected to business law issue. Refund policy is a thing that if you are setting up your business, you must think about refunds policy. You must have a law, on refunds policy if you are going to be selling goods and services. Police interfering with your deliveries is also a very urgent business law issue. Like I said, arresting the manager for private fighting can also be in fact because you may also be against your staff policy or your staff handbook. but it may not be as connected to your business as the others that I have mentioned. And of course, theft of company trade secrets is a hot matter. It's a matter that your business cannot survive without that. Also like you say, but you are right that this question is shades of gray, really. Then question 7, which is the last question, which is the most uncommon? Which is the most uncommon type of business form? Which is the most uncommon type of business form? A, limited liability company.
Or fund?
Business form, that's the business structure, which is the least, or which is the most uncommon. So limited liability company, public limited liability company, that's PLC, company limited by guarantee, or unlimited liability company, that's unlimited company. So which is the least common?
Unlimited company. Unlimited company.
Anybody thinks different? So we got that. So unlimited company, like I said, in Nigeria, as much as we know, I think Mobile Unlimited is about the only unlimited company. So limited companies are a lot more popular. So for instance, we have close to 2 million limited companies registered. Business names, I think as at last count, we have over, I think close on 3 million, if I remember correctly.
Wow.
Incorporated trustees, we have about maybe 200,000 to 300,000 of them. So, but limited companies are about the most popular. Or PLCs are also not too many. We don't have too many PLCs. I don't think PLCs in total we have would exceed maybe 1,000. I'm not sure they are more than that, because of course not all PLCs are listed on the stock exchange, but most of them are listed, but not all are necessarily listed on the stock exchange. So
does PLC mean public limited company?
Yeah, public limited company, yes.
Okay.
Yeah, that's what PLC means. So these are the companies that can sell shares on the stock exchange, that can raise capital from the stock exchange. So Deborah, I see that this is already 7, and we have to end by 7:30. So I don't know, should we do the next lesson, or we have to put it off? I don't know, for the sake of time. So Deborah or Mr. Nelson, would you give us guidance? Should we proceed or?
Good day, Barrister Marx. I must thank you very much. I think for your sake, and for avoiding intellectual constipation.
Exactly. I think so too.
I think a lot has gone down today, and we need to give ourselves 2 weeks to digest, ask a lot of questions on the platform. I want to thank everyone. Just remember that Barrister Marx, as you can see, his passion and commitment to delivering this training this is a passion. So if you have any question, all the resource persons that have come and that will still come, again, I'm very much willing to have conversations with you. Like I said, Barrister Marx is not just a local lawyer; it's an international lawyer. He's a lawyer that has often at the Nigerian Bar Association meetings. He has been called to present regularly at the MBA meetings. First time I met him always presenting on radio here in Abuja. So to have him here with us is massive. It's massive. I mean, if he charges you less than 1 million naira for any show in court, you are lucky. In fact, yesterday, one of my friends that Barrister Marx is representing was calling me and said, please help me beg him to reduce the fee. Help me beg him to reduce the fee. So for him to spend almost 3 hours and 20 minutes now with us, I know that is money. That is money. Thank you so much, Barrister Marx. We are so happy. I'd like us to please say, unmute your mic and just say, thank you, Barrister Marx. Please, just help me do that.
Thank you, Barrister Marx.
Thank you, Barrister Marx.
Thank you so much, Barrister Marx.
Thank you so much, sir. God bless you.
Thank you, sir.
Thank you.
One day we will make you proud.
Thank you.
Thank you all. Thank you all. It's been my pleasure to be here, and I look forward to our next session.
Thank you, sir. Thank you.
And just to assure you guys, this is just the beginning. We've not done law of contracts yet. We've not done intellectual property protection yet. We've not done kind of types of shareholding. It is just the beginning. So the materials will be shared. Please read them and then do further research. Like we always say, the materials provided at the EMP, is just an introduction to the book. The book you still have to read and research. We're here to guide you. This is just a teaser to say these are the curriculum of things you ought to know. So your journey in business law has just started, and we're happy that you stuck through the session and made it. Please, like we said earlier, we still have 2 weeks to have new people join us. 2 weeks. We have about 16 persons on this call. Our goal is to have at least 40 persons in each of our sessions to make it worthwhile for our resource persons who are taking their time to make this happen. So mobilize your friends, partners, those that you think that need this session. We still have 2 weeks window for them to join. Once again, thank you, Barrister Marx. We are so grateful. Thank you, everyone. God bless you. Good night.
Good night.
Thank you, sir. Good night.
Good night, all. Have a wonderful week and see you soon.
All right. Thank you, sir. Good night.
Good night, everyone.
We didn't pray.
Pray for us.
It's not late, though. It's not late, though. Pray for us. Pray for us.
In Jesus' name we pray. Our Heavenly Father, thank you for such a wonderful session this night. Father, we thank you for the resource person you used this night, Father. Virtue must have gone out of him, Father. We ask you to replenish more virtues into him in Jesus' name. Heavenly Father, we that have just learned so many things this night, Father, help us to implement it in our daily lives so that we will grow and maximize thy kingdom in this earth. These are more we pray in Jesus' name. As we are going to sleep this night, Father, give us a wonderful night's sleep. May we rest and may it please you to wake us up with strength the next day. This we pray in Jesus' name. Amen.
Good night.
Good night.
Good night.
Good night. Good night.